until after 51 years.
All right, let's head back into the courtroom where we picked it up last hour. This is the jury listening to Agent Brian Pritchard. He is interviewing defendant Karen Murray. It's audio only. This is after her mother's death.
Did your dad come and look and then call 911, or had he?
He came in and looked at it. Yeah, and I was like, this is serious. Call the ambulance. Call 911.
So we get just a little bit more detail about the day. So you don't know of any injury. You just happened to notice some swelling.
Yes.
You thought it was normal swelling.
It was normal swelling.
Okay, and then you watched it over a few days.
Yes.
Is that right? And the swelling started going down.
Maybe just like a little millimeter or something.
Okay.
It was like it was going down.
Gotcha. And then you just mentioned something about it looked like maybe pus. Did you say that there was? Okay.
Yes.
So there was when the swelling went down, there was a sore developed, or what did it look like to you?
It was ankle was kind of raised a little bit plus. Maybe with a little, I guess a little sore on top of the thing. I was just.
All right, this is very difficult to hear, so let's not waste any more time with that. We're going to move ahead to the actual testimony from the agent that conducted the interview, but the question is that we've heard rumblings that there's a chance that one or both of these defendants could take the stand. Matthew Mangino is still with us. This is a heartbreaking case on so many levels. These two, their appearance in court lends one to maybe think, oh boy, they sure were in over their head. And that was the argument from both attorneys in the opening statements. Taking the stand could help them or really hurt them because they look the part right now, but if they are more coherent than one might think, then that could be trouble. What would you look for if they end up taking the stand here?
Well, Ted, we know and have talked many times that the defendant taking the stand is probably the most important decision that the defendant and with his advice or her advice from counsel makes during the course of a trial. Obviously, this is a very tragic case. The facts are really horrific, but it may be helpful if one or both defendant, tries to explain their thought process or sort of lack thereof, why they didn't realize the magnitude of the situation as it existed with regard to the care of their mother. It's always a risk. And certainly, as you said, Ted, if they come across as understanding the gravity of the situation, then why didn't they act or act differently? So it's a double-edged sword, and one that I'm sure defense counsel has thought about, very specifically as they prepared for this trial. Yeah.
And you wonder how many members of the jury have dealt with a version of taking care of an older parent, the financial strain that creates, the different It's just a horrible thing that people go through, and this is an extreme example, but we'll see. Let's do this. We'll get this fast forwarded to the point where the detective that conducted the interview is on the stand telling the jury his takeaways from it. That, when we come back, plus 10 hours, 36 minutes, and counting. Karen Read jury continues to work, trying to sift through 31 days of testimony and come up with a verdict. Will they? Stay with us.
His action was just to pull out the revolver, and it went off.
Two people accidentally shot.
Alec Baldwin was the actor on set. Alec Baldwin? Yes, sir.
Hurry, hurry, hurry was the motto on the set.
Right away, let's reload.
Alec Baldwin claims he didn't pull the trigger. Well, the FBI disagrees.
It's not going to fire. until you pull the trigger.
They really do have to show that he couldn't care less.
The Case Against Alec Baldwin premieres Sunday, 9/8 Central on Court TV.
Welcome back to Court TV Live. Alec Baldwin, that's our next big case. That jury selection starts July 9th. That's if the case moves forward. We'll find out tomorrow if the judge agrees with the defense and throws this case out. One would think that's unlikely, but we'll find that out, that decision out tomorrow, and then July 9th jury selection, and we will be there in force. And catch that documentary this weekend, Sunday night, 9 o'clock Eastern time. It's good. Before we get back into court, a quick update out in Idaho, where Bryan Kohberger is expected to be back in court for another pretrial hearing later this afternoon. The hearing is expected to address some scheduling changes as well as any outstanding pretrial motions, proposed jury instructions, witness and exhibit lists, et cetera, et cetera. He, of course, is charged with 4 counts of first-degree murder in connection to the fatal stabbings of 4 University of Idaho students back in November of 2022. That hearing begins 1 o'clock Eastern. We'll keep a close eye on it here and bring you updates throughout the day on Court TV. Meanwhile, we're on verdict watch in Massachusetts, of course, for the killer or cover-up trial for defendant Karen Read. The jury has been deliberating now for 10 hours, 42 minutes over a couple days. Once we see any movement in the courtroom, we'll take you there live. Our cameras are also in Tennessee, where testimony continues in the brother and sister murder trial. Siblings Karen and Michael Murray are charged with murder for the alleged neglect of their mother. We've moved it up a little bit, got through that unintelligible interview. So we're getting to the point now where the special agent, this Brian Pritchard, who conducted the interview with Karen Murray and Michael Murray, is on the stand answering questions in front of the jury.
Questions there, I think, during the conversation with Karen Murray, you talked about the mechanism of the injury.
Yes.
Sounded very medical and sounded like you knew what you were talking about.
Somewhat.
Have you had any experience in any kind of medical services or the practice of medicine or anything?
I was an advanced EMT in the state of Tennessee for several years. I worked my way through college in the back of an ambulance.
Okay. So when you're using that kind of language, it's because you're speaking from a point of knowledge.
I'm familiar with certain terminology, yes.
Okay. We'll do it in reverse order. We'll start with what we heard today,
Okay.
and then go back to what we heard yesterday from Michael Murray. The first person you were to interview back on August the 30th, was that Karen Murray? Or do you recall?
I think it was Tony Murray.
Okay.
Or, I'm sorry, Edwin. I think I spoke to Edwin first.
And then the second one would have been?
I can't recall.
Okay. Going through the audio interview you had with Karen Murray, what are some of the things, if anything, that stood out to you when you did that interview?
Oh, first and foremost were some inconsistencies. Some statements that were made to me that didn't fit the evidence that I had at the time, and this was based on witness interviews, conversations with hospital staff, to include the attending physician at the ER, medical records. The glaring inconsistency was the statement that Miss Murray had been up the day before. I found it hard to believe that actually occurred, based on the descriptions. And you recall in the interview, I asked for the description of a normal day, an average day, and one individual, Michael, would be on the right, Karen would be on the left, or vice versa. When they would get her up, the evidence that I had received prior to this interview would suggest that would be quite impossible.
And why is that?
The decubitus, for one, and obviously that the the information that I'd received from the attending physician would suggest that there was no way that there was going to be weight bore on that ankle.
Were there other inconsistencies that you saw in the statements given by Ms. Murray?
I don't know if I would call this an inconsistency as much as an observation that the canceled appointment for June and the information that Ms. Murray conveyed to me about her mother's decline, beginning 6 months before the incident that precipitated the 911 call. I was curious as to why that June visit wasn't scheduled as it should have been if in fact those the injuries I saw in photographs would have had to have been noticeable. And can you repeat the last part of the question one more time?
Let me ask this way. What other things were of significance to you when you were reviewing that interview?
I got you. The another would be the when I reviewed the 911 call, there was mention of a fall, a potential fall, and that was never mentioned. I mean, I had to address that in the interview, and I never quite got a clear answer. I never quite got a consistent. There could have been a fall. There wasn't a fall. It just went back and forth a little bit. So, other than those, I can't really think of anything else that.
Okay. During that interview, sores.
Yes.
That had formed.
All right, let's get a break here and get you back into the courtroom for more, plus updating Karen Reed at the top of the hour as the jury continues to deliberate 10 hours, 49 minutes and counting. We'll check in with our Matt Johnson a little bit later. And then also monitor Tennessee. Stay with us.
On the next episode of Accomplice to Murder.
It looked like Virginia and Norman really had a wonderful relationship.
But then greed planted the seeds of a brutal murder.
$1.1 million in benefits to Virginia.
And when she couldn't find a hitman, she decided to use her son, Jason.
She said, no one is going to be getting in the way of me collecting that insurance money, or they'll wind up just like Norm.
Accomplice to Murder with Vinnie Politan. All new episode, Sunday night, 8/7 Central.
Only on Court TV.
Court TV Live. Of course, we're on Verdict Watch in the killer or cover-up murder trial for Karen Reed. The jury has been at it now almost 11 hours, 10 hours, 53 minutes and counting. As soon as we see any movement in that courtroom, that's a live look inside the courtroom in Dedham, Massachusetts. Our favorite fan working away, and we all wait to see what will happen. As soon as anything happens, if they go on the record, we, of course, will go in right away. We're also watching testimony in Tennessee in this brother and sister murder trial. The defendants, Karen and Michael Murray, are charged with first-degree murder and aggravated neglect in the death of their mother, Sheila. They face a potential life sentence without parole if convicted here on the top charge. Let's go back into the courtroom now. We'll pick it up right where we left off. This is a direct examination of the TBI special agent, a guy by the name of Brian Pritchard, who interviewed the defendants.
Do you recall Ms. Murray talking about what process she was using to take care of that?
I do. It was a cream. I recall her saying that when she would see a red spot, it would, and I'm paraphrasing. I'm not using the exact words she used. They're available to review. That when she would see a red spot, she would apply the cream, and they had to be very careful about what they used because of Sheila Murray's skin sensitivities.
Okay. So one of the things they noted is that Sheila Murray had a skin sensitivity.
Yes.
Okay. I believe there's a part in there where she talks about, you ask about the day of when the ambulance was called, about
Yes.
when was Miss Murray changed?
Yes.
And about what time of day did she say that was?
It was the day before. They had gone.
Let me rephrase that.
Yeah.
You're correct. You're correct. What time had they went to go change her for the day?
Between 5 and 6, depending on who you.
Okay. And that's for someone.
Depending on which interview.
And that's with someone who has sensitive skin.
Yes.
Okay. She talked about that foot being bandaged.
Yes.
And she referenced a medical condition that her mom had. Do you remember what that was?
No, I'm not off that. I'd never heard. I wasn't familiar with that condition. It ended with edema, and I know that's swelling. I mean, that's.
So, do you remember how she described the type of swelling that she was wrapping the injury for?
I can paraphrase.
That's fine.
There was a red spot at some point. There was a little swelling. It was my understanding from the response to the question was that something that occurred as a result of the edema, and I recall there was a red spot that turned into what she described as a pimple.
Okay. And the bandaging, that was for the purpose of the maybe lymphedema?
I can only assume it was to reduce the swelling.
Okay. Caused by her normal swelling of her legs that she had?
The edema, yes.
Not by any injury or anything like that?
That was my conclusion. That's the way I took it, yes.
Okay. And there was no mention of seeing blood any of the other times that she had changed the leg?
No, not the day before or prior.
Okay. And is that consistent with the medical findings that you received during the course of your investigation? Due to that injury, would you expect there to be blood?
I would expect there to be blood, yes.
Okay. Let's talk about your interview with Michael Murray. Were there things that stood out in that interview?
As I testified a minute ago, the mechanism. First off, the mechanism as to how Sheila Murray was moved about. I can't see how that could actually be. I'm not going to say it's impossible, but I can't. It's unlikely that someone would get under each arm and that she would bear weight. I found that to be an inconsistency. Initially, Michael Murray had indicated that she had, in the interview, he had indicated that that Sheila Murray had been changed that day. And then when I readdressed the question, she had not been up that day. No one had been in, had went to check on her, and apparently until between 5 and 6 p.m. And that's when, obviously the ambulance was called. Michael had indicated it was the day before.
Okay. You said, are you aware what time the ambulance was called?
Not precisely.
So whatever time that the ambulance says that they were called, that would be the accurate time, right?
Yes.
Okay.
Yes.
Was he able to provide you with a reason, the mechanism for the injury?
No, not that satisfied my question. Actually, initially, he had suggested that he was not strong enough to do that.
Did you accuse him of doing it?
I'm sorry?
Did you accuse him of doing it?
No, not.
Make any reference that he had did it somehow?
No.
Okay.
I did not. Quite frankly, I think that I remained fairly unaccusatory throughout both interviews. But anyway, also the statement that it's like someone broke into the house and did this. I mean, the explanations for the injury were quite frankly all over the place. So,
did he indicate whether anyone else knew how her injury occurred?
As I recall, the final question was, do you have any idea, or does anyone else have any idea? And his reply was no.
Okay. And is that consistent with what you learned from medical personnel and the 911 call with regard to whether others had a reason for her having that injury?
Make sure I understand the question.
You listened to the 911 call, right?
Yes.
Was there a reason given for the possible injury in the 911 call?
I heard fall.
Okay. So, and you are aware that someone from the family made that call?
Yes.
So, is that consistent with what Mr. Michael Murray said, that no one knew what happened?
That's not consistent, no.
Okay. And did you learn about how many times a day that she was being changed?
It ranged from 3 to 4 to a couple. And that's the only numbers that I remember.
Okay.
We're talking about Michael Murray, correct?
Yes.
Yeah, okay.
And going back to Karen Murray for a minute, she talked about at one point sometimes that they would not check on Sheila Murray. Do you remember that?
We are going to slip on a commercial break. The jury and Karen Reed, 11 hours. They've gone over the 11-hour mark in deliberations. When we come back, we'll update you on the latest as we wait for a verdict. Stay with us.
Reverie. Thousands of women have restored their vaginal moisture. Join them at Reverie.com.
Welcome back to Court TV Live. I'm Ted Rollins, along with Julia Janae, as we, along with you, wait for word out of Dedham, Massachusetts. We're on Verdict Watch.
That's right. In the Killora cover-up murder trial, Karen Reed is the defendant, and this jury has been deliberating now for 11 hours and 6 minutes. We haven't heard a lot from them today. We heard some peeps from them yesterday with a question, but nothing so far as we go into the afternoon.
Is it getting to, well, what's the point where you're thinking, oh, could it be hung?
I think if they don't come back today, that's what I think would be
makes sense.
that territory of...
There's so much to go over. So you can't leap to that, too early.
Right. But they're not asking for anything, meaning they think they have everything that they need so far, perhaps. You recall, if you're just joining this story, that Reed is accused of backing her SUV into her Boston cop boyfriend and then leaving him to die in the snow.
And the defense, of course, has the claim, and they went all in on this during trial, that this was a massive police cover-up.
We are also in Tennessee this afternoon. Testimony is underway in the trial for a brother and sister who are charged with the first-degree murder of their mother. Karen and Michael Murray are charged with that and aggravated neglect for her death. Sheila is the victim in this case, Sheila Murray, and she died in August of 2019.
She was found laying in a bed soaked in urine and fecal matter. She also had an exposed tibia from a compound ankle fracture. The details of this case are really, really sad. And we'll be dipping back into the courtroom a bit later. But we want to start with Karen Reed because let's face it, wherever you go, people are talking about this, and people are waiting. As soon as there's an alert on someone's phone, it's going to be all eyes. It's one of those cases.
It's one of those cases that has divided people, divided newsrooms a bit, divided workplaces and people online. They really, I see them in the comments going after each other because people are so rooted in one way or the other, guilty or not guilty. But one thing they didn't get to hear at this trial, even though we've heard Karen Reed outside of the courtroom, sometimes talking to legal correspondent Matt Johnson there on the ground, we didn't hear from her on the stand during this trial.
Which, let's face it, that was a good choice because the setup from, they seemed to be doing well. The defense was doing well, and if you put the client on the stand, everything else goes out the window. And if jurors don't like her, don't believe her, then there's a problem. And one of the things that you would have had to have addressed was that I hit him, I hit him, I hit him. And that was the theme of Adam Lawley's close. That would have been the difficult decision for her. Whatever she said to the answer of, did you say I hit him, jurors might, a portion of the jury might not believe her.
And they may be wondering, though, in the deliberation room, why didn't we hear from her? And all we're left with is what other people said she said. Let's take a look back at some of those moments from court, because there were several. There were several witnesses who said what they heard Karen Reed say. Take a listen.
Ms. Reed was visibly upset. She kept saying, this is all my fault. This is my fault. I did this. And she was very hysterical. And she kept asking, he's dead. Is he dead? Is he dead?
As I was ventilating, I was able to ask, did anybody see anything? What happened? And there was one individual that replied several times, I hit him, I hit him.
She just repeated the phrase over and over again, I hit him, I hit him.
Do you recall specifically what, if anything, that person said?
All I recall her saying was, is he alive?
When I asked her if there had been any significant trauma that happened before this.
What, if anything, did she say?
So she said, I hit him. She repeated it. There was a woman standing across from her who I believe at that point said, you're hysterical. You need to calm down. You're hysterical. She repeated, I hit him.
You indicated that the defendant said, I hit him, is that correct?
Yes,
That's something that she said once or more than once?
3 times. I hit him, I hit him, I hit him. Earlier, it was could I, did I. When she spoke to the paramedic, it was crystal clear. I hit him.
Paramedics, firefighters, and Jennifer McCabe there at the end. Important to note, though, the other woman who was there with Karen Reed and Jennifer McCabe was Carrie Roberts. She didn't hear, I hit him, I hit him. She heard, did I hit him? Could I have hit him?
Yeah.
And the defense chose not to even cross-examine her.
Right, because, and again, there's where Karen Reed could have maybe cleared it up or convinced the jury that she did say, did I hit him? Did I? Because I was wondering what happened to him.
Didn't remember.
Yeah. The other part of that equation, though, is if you drop someone off at a party and you go home and you don't think anything, you wouldn't think after you drive away, I wonder if I hit that person when I dropped them off. You know, and so the next morning, why is she saying, did I hit him?
I've asked this question of many people, Ted, and I've heard viewers
I guess because
respond to
he's
this.
laying
They
in the
say
snow.
sometimes people just feel guilty about things, not necessarily because they are guilty, but just they wonder, could it have been my fault? Just leaning into that.
When you're wondering how did he get here in the snow? Maybe I hit him.
I
that
was the
way.
last person
Yeah.
around him and just going through the
That makes
possible
sense.
scenarios. So she could have cleared it up. She could have perhaps done that, but there were some more problems.
Yeah, if
to what
she would have
would
taken
been
the
faced
stand,
with.
she also would have had to have talked about those voicemails. She drops him off, and then, of course, we all heard the voicemails that she left for him in the subsequent minutes and hours. To me, and we'll listen to the voicemails, but to me, these actually help her for the knowledge of if she thought she hit him and then left mad, really you're gonna call him and call him all those names and be crazy and all that? Like, no, you'd be. You wouldn't.
And it's
I
so
can't imagine
close
you
in
doing
time.
that.
So
Yeah.
close in time, 12, 25, 26 is when she would have dropped him off. And that first voicemail is only about 10 to 20 minutes later.
Let's listen to some of the Karen Reed voicemails left on John O'Keefe's phone.
Now, as far as this first voicemail, what time did this occur?
12:37 a.m.
And with the court's permission, if I could play that for the jury.
Yes.
Third message, what time is that received?
12:59.
John, I'm telling you, kid. Nobody knows what the he wants. Her.
With regard to the fifth message, what time was that received by Mr. O'Keefe's phone?
1:11 a.m.
Yes, 1 in the morning, I'm with your niece and nephew. You pervert. You're
In the sixth message, sir, what time was that received by Mr. O'Keefe's phone?
1:18 a.m.
John, I'm going home. I cannot babysit me. I need to go home. You are using me right now. Another girl, he's sleeping next to me. You're a loser.
The seventh message, sir, what time was that received by Mr. O'Keefe's phone?
5:23 a.m.
It would have been difficult for her to take the stand, hear those played out, and then asking what her state of mind was. But when she says no one knows where you are, I wonder who is no one? Who is asking where he is? And she's the one who knows where he is. He doesn't have a car. So she's asking where he is, even though
those voicemails are
she
insane.
dropped
Like
him off.
she's obviously it's been established she had been drinking on some level, and that. All right, she was in a crazy mindset. I actually think it helps her in the, if you're going to argue that she knew that she hit him, why would she say all that craziness?
No, I think it doesn't make a lot of sense, for sure. But I'm not sure why she's calling him so vigorously when she drove away from him, left him without a car, and then she's acting like she doesn't know where he is when he hasn't answered the phone, so he would expectedly be where you left him.
One of the things that really bothers me about, and if you believe Jen McCabe, and a lot of people don't, if she told Jen McCabe that I left John at the waterfall, and then Jen had to catch her and say, well, we saw your car outside, Karen. If you believe that, that's, to me, disturbing for her. Why would she lie and say, hey, I left him at the waterfall?
Do you think the prosecution spent enough time focusing on that
No.
in the closing arguments?
I don't, and I don't think they spent enough time on it. It was intermixed with all the other Jen McCabe stuff. The problem, I think, is that do you believe Jen McCabe for the jury? Personally, I thought she did a good job on the stand. And believe me, I think there's reasonable doubt for the roof in this case. But I have a tough time thinking Jen McCabe was all in. She's a mother, and her aggressiveness towards the defense was from a real spot of being accused of something she didn't do,
Right,
in my
you definitely
opinion.
could feel that inside of the courtroom. You could
Yeah.
see it even when she was there in the gallery that last day
Mad
of trial.
dogging her.
So a question about reasonable doubt in this case, because we've had our social media polls about this case. Our social team has been asking viewers, and overwhelmingly, there's been the majority saying that it's going to come back not guilty. I would say a follow-up is, do people believe that she's actually innocent, or do they think that the prosecution did not prove this case beyond a reasonable doubt? And I think there's a distinction there in terms of whether or not she did this or whether or not the prosecution proved it, especially with all of those problems with the investigation.
Yeah, and there's no other case in recent memory where people have so many different versions of what they think probably happened. And that is reasonable doubt in my mind. That at the end of the day, no one knows, because those injuries are too much, and those independent investigators who were hired by the feds, you know, it makes sense what they said, that the head injury could not have been caused by anything but concrete. Well, how did his body get up in the lawn if he was launched? Maybe he got up, maybe he walked there, maybe something else happened, maybe, and the scratches on the arm. There.
Is this what they're
What
talking
happened,
about
Julia?
inside of that deliberation room? That's what I would love to be, a fly on the wall to know.
Absolutely.
What are they focused on? What are they thinking about? Hopefully we get a question from them that will help. But you know, there's another moment that these jurors heard in terms of Karen Reed's voice. Again, they didn't hear her testify, but they heard her through other means. They saw body camera footage of her when she discovered John O'Keefe, when the police arrived, but also after she was detained the second time, after she was first charged with manslaughter, then they upped the charge to second-degree murder.
And this is
brought
after
her
they
in.
had seen some of the discovery. This is after because remember, the initial court appearance with Yannetti, Yannetti is saying, hey, this woman loved him and this was probably an accident.
An accident.
Now all the discovery comes in, the arm injuries, they're thinking, oh, no. And Karen's probably thinking, I did not do this. So by the time that she's rearrested, they've already got their sort of mentality, oh, boy, this is a cover-up.
Yeah, let's take a listen to that moment. It's a body camera footage of an officer who's essentially reading her rights the second time, and she talks about a joke that she thinks everyone's in on.
So, initially, your arrest was on probable cause out of the district court, okay? So the charges that you were arrested on initially were out of district court, out of Stoughton District. That's where the arraignment was. It was district level charges. Today, grand jury indicted you on these charges, which is second-degree murder, vehicular homicide, and leaving the scene of a death, okay? So those are the charges that grand jury indicted you on. So now you're being charged and will be arraigned in Superior Court, Norfolk County Superior Court in Devon. Okay? So
bail doesn't apply anymore?
Typically, I'm not, so we don't set the bail. But typically, once murder comes into play, people don't get bailed out.
So it's not manslaughter anymore, is that the difference?
That's correct. It's a higher degree of taking a life. Okay? So that's the charges that you're being charged with now. And you were indicted by grand jury.
Okay, you're aware he was beaten up by Brian from Colin Albert. I mean, we're all in on the same joke, right? My taillight was cracked and John was pulverized.
Okay, you need to abide by the rights that were afforded to you, okay? So you can talk if you want. If you want to tell us what happened, that's fine. We'll listen, but you were ready to your rights, okay? And I'm sure he's going to do it again. All right. If you want to talk to us, you want to give us a story, definitely. We'll take it.
No, I mean, I know you already know the story, so I don't need to.
That one's a head scratcher. in terms of what it means? Did the jury pay attention to it closely, or is it something that may have gotten lost with everything else that came out in this trial? But
you remember the
they got to see
judge
her.
ruled that the jury didn't see the video. It was just the audio because they didn't want to show that she was at a police station.
Right. And, you know, I have mixed feelings about whether or not it would have prejudiced her. They know that she was indicted and may have expected that she was arrested. And when they're hearing her being interviewed by a police officer, you know, she's not in cuffs that you can see in that video. But it sounds like there's some kind of a story, something that she's trying to get from this officer, and he's saying, no, let's play it by the book. One of those situations where this officer is actually playing it by the book.
Oh,
in
this officer bailed her out because, you know, he stopped her and said, whoa, stop talking.
Yep. Reminder of her rights.
Let's get a break. We're continuing to watch the clock and that fan twirl around and around. Our camera's inside the courtroom. Matt's outside the courthouse. There are people outside the courthouse, lots of them. We're all in the same boat. We're just waiting patiently for anything out of this jury. And if there's a question, if they're on the record, we're there. We're with you. So stay tuned because eventually it's going to come, and we'll be here for you. Plus,
still ahead, we are going to turn our attention to this brother and sister murder trial in Tennessee. We have a big question today on whether Michael or Karen Murray are going to take the stand. So don't go anywhere. More ahead on Court TV, your front row seat to justice.
A-list actor Alec Baldwin is cast in the real-life role he never wanted.
I turn cup because the gun goes off.
Criminal defendant.
His lack of gun safety is something that he's going to have to answer for.
We heard that this was a toxic set.
One more.
It's not his fault. He did nothing wrong.
Is there an actor's exemption from liability when they're handling a deadly firearm?
The Alec Baldwin manslaughter trial. Live coverage coming this July, only on Court TV.
Welcome back to Court TV Live. We're watching some developments out of the state of Michigan. A hearing underway for the defendant accused of driving her car into a boat club that killed 2 children at a birthday party.
What's happening now is a 2-day probable cause hearing. It's going to determine if there's enough evidence to move forward with a trial for 66-year-old Marcella Chedester. Prosecutors claim that Chedester was under the influence of alcohol at the time that she was behind the wheel.
The crash killed 2 siblings, 4-year-old and an 8-year-old. Over a dozen others were injured in this case. The prosecution played the surveillance video of the crash during today's hearing, and Chedester's interview with police captured on the officer's body camera just moments after the crash.
On a scale of 0 to 10, 0 being like you're stone cold sober, you can drive perfectly, 10 being you're passed out drunk, where do you think you're at right now?
7.
A 7? Okay. Do you think you're okay to drive?
I wouldn't want to drive.
They wouldn't let you drive?
No.
Okay.
The defense for Chedester claims that she was having a seizure at the time and lost control of her leg when she plowed into that building.
Tough to watch that for sure. Let's we'll have updates throughout the day here on Court TV on that case as it progresses. Meanwhile, the fate of Karen Reed, of course, is in the hands of this Massachusetts jury. They've been at it now 11 hours, about 11 and a half hours. We'll go into the court if there's any question. We're also going to be checking in with our Matt Johnson, who's outside the courthouse later in just a bit.
That's right, but we are also in Tennessee, where we're following the testimony for the trial of a daughter and son who are facing murder and neglect charges for their own mother's death. This was back in 2019. The defense claims that Michael and Karen Murray were in over their heads in caring for their mother Sheila, and that they didn't knowingly neglect her.
Let's pick up the testimony with Agent Brian Pritchard, who interviewed the defendant after their mother's death.
Context of where in the interview that one was.
It's about the middle of the interview, after you were talking about the bed sores, after the mechanism of injury. It was about the right leg. Do you remember her saying sometimes just with having our own lives?
Yes.
That they didn't check on her?
Yes, I do remember that.
And how would you describe her ability to describe her mother's prior medical record?
You mean her recollection of prior injuries? It was fine. I mean, I think she did. She had a good recollection. I mean, she was shady on dates, not shady, a little unclear on dates. It's an improper word, but as far as the conditions, I think she did a pretty good job.
She was able to recount where her mom had stayed before when she had her stroke.
Yes.
Her lymphedema issues, where
Yes.
she had been when she was very knowledgeable about her mother's history. Would you agree with that?
She seemed to be, yes.
Okay. Did she inform you of whether or not she had, in fact, discussed concerns she's had in the past with medical personnel?
She did. She did.
Okay. And did she give you a reason that she did not discuss her concerns with medical personnel when her mom's health started to decline?
No.
Okay. If you will please answer any questions that defense counsel may have.
Mr. Byrd, cross-examination.
Agent Pritchard, if I jump around on this, you'll have to forgive me. I'm going to try to keep it as in line as I can. If I jump around, just forgive me.
I understand.
Now, these two, when they came in to speak with you, they came in voluntarily. You didn't have to go out and find them and haul them in. Is that right?
I did not, no.
Okay. And when they talked to you about whatever happened to their mother's ankle, what they said was what came out of all that was that they didn't know for sure. They offered possibilities, but they didn't know for sure what had happened.
That's accurate, yes.
Okay. And the 911 call you're talking about, that was their father, Edwin Murray, who placed that 911 call. Is that correct?
I I believe that was I recognized that voice, yes.
Okay. So if in that call, if it's communicated that they believe the fall had happened, that's Edwin Tony Murray who is communicating that to dispatch. Is that fair to say?
That's fair.
Okay. Now, you'd said yesterday about the reason you didn't go out to the scene to take any photos that I believe Investigator Dunn had said that there was no scene to go examine. Is that right?
I don't believe I mentioned specifically who had told me that because I didn't recall. Okay. It could have been Detective Dunn.
Okay.
I'm not 100% sure who told me that. I know I was told that.
Okay. But you didn't make the decision. You took whoever it was at their word. You didn't go out and check it out on your own.
I did not.
Okay. So any of the things, contextual things that we might have been able to find out about that, things that you might have picked up on, we'll never know. And I'll give you an example of what I mean by this. This bedside commode, the things we've heard about here, the possible cream that could have been used for wounds, or the gauze that could have had blood on it. All these things, we don't know if it was still around or not, do we?
That's correct.
Okay. So all the things that we hear about the scene we have to depend upon people's recollection of those things. We don't have photographic, video evidence. We don't have anything of that nature, right?
No, that happens. It's not commonly, but it happens on occasion with TBI investigations. We're called in after the fact. So, had I been called on the 10th, that would be a moot point.
Okay. Now, when Karen Murray had said something about canceling this appointment in June, she said something about that she was feeling unwell that day, something to that effect. Do you recall?
She thought she'd possibly cancel it because she wasn't feeling well.
Okay.
And I took that to mean Karen Murray wasn't feeling well.
Do you have any reason to believe that she was being untruthful about that?
I do not.
Okay. And when she talked about her mother's, the foot condition that she talked about her mother having this, I think the lipedema, probably mispronouncing that, but, and that this was a condition her mother had had her whole life. Do you have any reason to believe she's being untruthful about that?
I do not.
Okay. Because as you said, she seemed to have a pretty good knowledge of her mother's medical history and where she'd stayed and all that, correct?
Yes.
Okay. Now, as far as the recollection of time goes, this was when? Do you remember what day this interview was on, or if you've how close in time, I guess, to
it was August 30th of 2019.
Okay, so this was 2 weeks, give or take, from when Sheila Murray had passed.
It was.
Okay, so fair to say this is a family that is this is a daughter and son who were still grieving their mother.
That's fair.
It seemed like to you that they were.
Yes.
Yes. Probably still a little bit emotional about it.
Karen Murray, as you could hear in the interview, she became tearful on occasion.
You had no reason to believe that was anything less than genuine. Is that fair?
That's fair.
Okay. The reason I ask that is in terms of a recollection of time and those kind of events. In your experience, interviewing all the years that you've done that grief, events like that can sometimes affect people's perception of time. Is that fair to say? In a general sense.
In a general sense, yes. I think that would be accurate. In a general sense, I can't.
Be clear. I'm not asking you to tell me what as far as like Karen Murray specifically. I'm not asking you to be a psychiatrist or anything. But
in a general sense, yes, I agree with you.
Okay. Now. Karen Murray had mentioned something about how her mother was getting harder to move in the interview. Is that correct? She was getting stiff, and it was harder to move her.
Yes.
Right?
Last 6 months, I believe it's in that part of the interview.
Okay. She also had mentioned in the interview that at times, she would attempt to roll her mother over to reposition her, and that her mother would roll back in the same position.
I do recall that in the interview, yes.
And she had mentioned something about trying to put towels or pillows or something under as a cushion because her mother kept rolling back in the same position.
Yes, that's accurate.
Okay. no reason to believe she's been untruthful about that.
I do not.
All right, we need a break. When we come back, we're going to check it with our Kelly Craft. She'll join us live right after the break for more on this very troubling and heartbreaking case. Stay with us. Plus, Karen Reed, 11 hours, 37 and counting. Back after this.
I'm Matt Johnson in Dedham, Massachusetts for the killer or cover-up murder trial. This is Court TV, your front row seat to justice.
Welcome back. We are watching the seconds tick by for this verdict watch happening this afternoon in the killer or cover-up murder trial for defendant Karen Reed. The Massachusetts jury has been deliberating now for 11 hours and 41 minutes. No movement from them inside of the courtroom today so far. But if there is any kind of movement or a question or a verdict, we're going to pause that clock and take you there live.
Yeah, it's, boy, we're waiting on pins and needles. We're going to check in with Matt, too. Matt Johnson, top of the hour. He's outside the courthouse. We're also keeping a close eye on this Tennessee case, the brother and sister murder trial. Joining us now to discuss that in studio, Court TV legal correspondent Kelly Craft. Good afternoon, Kelly. This case, this is so sad on so many levels.
It is so sad, Ted and Julia. So we've been following this case out of Tennessee. It's this case against two siblings, and they're charged with the murder of their mother. And we are hearing that this case may be in the hands of the jury later on today. Several witnesses who have already taken the stand for the state have said that this is the worst case of neglect that they have ever seen. The defendants in this case, you are looking at them right there, Michael Murray as well as Karen Murray. They are on trial for murdering their disabled mother, Sheila, in 2019. Now, Karen Murray, she has been very emotional each day of this trial, and prosecutors do say they neglected and abused their mother. A special agent was recalled by the state today to play an interview conducted with Karen Murray 2 weeks after her mother died at the hospital. Now, we're not going to play that for you because it was really hard to hear. Yesterday, the prosecution was having a lot of trouble with the audio. Today, they did play it. So in this interview, you can just kind of barely make out Karen just talking about the normal care of the mother, what they would do every single day to care for Sheila. Also, yesterday they played an interview that was done with her brother, Michael. So that one you can make out a little bit better. So let's play a little bit of that for our viewers now.
I know she had complained about some foot pain a little bit. I was like, well, Karen, I'm like, is her foot okay? And she was saying, yeah, everything's fine. And just that night, like I said, when I went to pick her up, her foot, like I said, had that damage to it. We don't know. I don't know how it happened. Okay. I know that I didn't do it. I didn't have any contact with it. How it came like that, I don't know.
The state's last witness is expected to be Dr. Emily Cook. She is a forensic pathologist. It is unclear at this time if the defendants will take the stand, but again, we are hearing that by the end of the day, the jury could have this case, Ted and Julia.
Yeah, which would lend, if true, lend one to think that defendants are not taking the stand because we're already into the afternoon and
possibility, or I mean, it seems like they're moving through this case really quickly. Thank you so much, Kelly Craft, for that live report. Joining us now to discuss this, criminal defense attorney and civil trial attorney Austin Dove is joining us. Austin, this is a case that so many people are talking about in terms of these defendants and whether or not first-degree murder was an appropriate charge here. They're watching kind of the movements of these two adult children. They're in their 40s. They have always lived at home with their parents. They had another sister who went off to college, had a life outside of this family, but they have lived there. And there have been questions about their mental capacity, not necessarily from the state, because the state says they knew what they were doing and they should have taken care of their mother more. But knowing that that may be something that people watching this trial and perhaps the jurors are questioning, would you as a criminal defense attorney work through whether or not these clients should take the stand to perhaps get across to this jury their lack of knowledge or understanding or intent to kill?
Yes. Well, absolutely. I mean, the appearance of your client matters all the time, and the appearance of these two defendants is going to play a big role in the jury's perception about what they saw, what their actions were. And in terms of them taking the stands, of course, we know the conventional wisdom among trial attorneys is that your client doesn't take the stand absent really compelling reasons to do so. We also, in this case, have the tape, the audio tapes of their interviews, as discussed recently by the IO, the investigating officer detective, and that's been played for the jury. Unless there's something that they can add in color or context that's not already out there in front of the jury in terms of evidence produced by the prosecution, there's really no reason to have these folks take the stand. It's a big swing for defenses, for the prosecution to go first degree on this one. because there's so many other factors that seem to be in play about just their mom's illness and other conditions.
And I think, too, to Julia's point, where you look at these two sitting at the defense table, the young woman is in tears a lot, very empathetic. And the young man, not so they're in their 40s. He's playing he looks like he is kind of out to lunch on some levels, and it doesn't look like it's an act by any stretch, because this has been days. The jury's had time to watch, absorb, and Austin, to your point, hear them in their own words. Putting them on the stand, they might kill what they've already sort of developed through the opening statements from their attorneys, that they were not prepared to take on this task.
Yeah, right. I mean, if you think about just the general idea, it's a lot to take on the responsibility of caring for an ill parent. These are not medical professionals. They are not equipped to deal with these kind of conditions. Defense counsel mentioned lipidemia, which is a condition that can cause some stagnation. Mom's not able to be mobile. They've got to figure out how to rotate her, feed her, change her, other things that they really have to get involved with that are just beyond their ability and capability. They probably meant well, but so falling to that level of not being great at caring for your mother is one thing, and of course we all want to care as much for our parents as possible. But it's quite another thing to say it rises to the level where they had some intention, some causation that you can directly link to their behavior, their conduct, that says these individuals were so reckless that it rises to the level of they knew that they were placing their mom at this increased great risk. And from what I'm gleaning so far, there are going to be some holes that the defense is going to be able to use in terms of filling out all those boxes to show that it's that level that shows you got causation and it's really a murder here. I think it may fall into a different category, perhaps into something in the sort of manslaughter category if the jury and the judge instructs on alternatives.
Yeah, we'll see if they include that in the verdict form, if they have other options. We just know now, as far as the indictment, murder in the first degree, and then abuse by neglect as far as the charges against these two. We're going to get to a break and then get you to more of the cross-examination of that investigator who interviewed the Murray siblings. That's next.
On the next episode of Accomplice to Murder.
It looked like Virginia and Norman really had a wonderful relationship.
But then greed planted the seeds of a brutal murder.
$1.1 million in benefits to Virginia.
And when she couldn't find a hitman, she decided to use her son, Jason.
She said, no one is going to be getting in the way of me collecting that insurance money, or they'll wind up just like Norm.
Accomplice to Murder with Vinnie Politan. All new episode, Sunday night, 8/7 Central.
Only on Court TV.
Welcome back. We are following some breaking news just into our newsroom out of Georgia. A search is underway for 2 missing firefighters.
Yeah, Chandler Kubander and a female firefighter by the name of Reagan Anderson are missing, along with a 2017 Ford Focus. Kubander's family last heard from him yesterday, and they don't believe that he left willingly.
Now, police believe that the 2 are headed to Gatlinburg and the Pigeon Forge area in Tennessee. There are reports that the pair may have been involved in a relationship, and online records show that Anderson was recently arrested for vandalizing the vehicle of Kubander and then released after that. So we'll, of course, keep you posted on any developments in this
on the
case.
surface, a very strange story. We'll keep you posted if there's any developments throughout the day here on Court TV.
And we are in a verdict watch in Massachusetts. We are watching the killer or cover-up murder trial for defendant Karen Reed. The jury has been out 11 hours and 54 minutes, getting close to that 12-hour mark. We haven't heard any movement from them today. They had a question yesterday wanting to see a certain report about the search for evidence, but today, nothing, and they didn't get that report yesterday.
No, but they've been hard at work since convening about just after 9 o'clock this morning. Meanwhile, back to Tennessee, where we've been watching testimony unfold in the brother and sister murder trial for the defendants Karen and Michael Murray.
Let's pick up the cross-examination of Agent Brian Pritchard by Karen Murray's attorney.
Fair to say that on several occasions during her interview with you, Karen Murray had mentioned that she didn't want to make her mother uncomfortable or to try to hurt her in getting her to do certain things. Whenever she was feeding her, repositioning her, she wanted to try to keep her mother comfortable. Was that your recollection?
Yes, that is.
Okay. And she said the decision to bring her mother home from Cornerstone, that was her father's say. Is that?
She did say that, yes.
It's fair to characterize whenever she's discussing this injury to her mother's ankle that when they realize what it is they're looking at, that's the point, by what she told you, that's the point that I guess Tony Murray went and called 911.
You mean the part where they saw the bone sticking out?
Where they
Yes.
realize they're looking
Yes.
at bone sticking out of.
Yes.
Okay. And I believe right after that in the interview, Karen Murray said that if she had seen bone previously, that she would have called for help. Is that correct?
That's correct.
Okay. Now, Karen Murray also repeatedly expressed, I guess, if I can characterize, and you tell me if you disagree with this, of course, but it seemed she repeatedly characterized her, that in hindsight she realized that she, was, I think in her words, stupid for thinking that she could handle this stuff herself.
She did say that, yes.
Said that on several occasions.
She did on several occasions, yes.
She also said that she often had to, that their father wasn't able to help lift. Is that correct?
Correct.
Okay. And that she would have to wait on her brother to be able to come help her if she needed, that she had to have her brother help lift her mother.
I do recall that, yes.
Okay. Now, when they talked about getting her out of bed, I don't know, Karen or Michael, neither one, when they talked about getting her out of bed, said anything about setting her down to where she had to put weight on her feet or anything, did they? Clarify, they said we got her out of bed, but they didn't say anything because you said an answer about putting weight on this ankle, but I don't think they either one said anything about putting her down on her feet or anything like that.
Are you asking me about both?
Yeah,
both interviews.
Neither one said anything about putting weight, putting her, put weight on her.
It was addressed. It was addressed in Michael's interview toward the end when offered a potential mechanism. And it wasn't disagreed with about turning her in the wrong way to sit on the bedside commode.
Okay. But that, from what I gathered from that, it seemed as though Michael Murray was offering up possibilities about how his mother's ankle could have gotten hurt, not that he knew that for certain.
Correct.
Okay.
There was even a point in there that I offered it up.
Okay. Now, with regard to Sheila Murray's decline, her physical decline, I mean, you gathered some of the medical records during the course of this as part of your investigation, correct?
Correct.
Okay. You didn't see anything in those records that was, I mean, you with your background especially, you could see that there was obviously a decline that was happening in Sheila Murray from when she left Cornerstone to the last records you could get your hands on. It seems apparent she was declining. Is that fair to say? To some degree. I'm not asking you to tell me to.
Yeah, I mean, it seemed fairly minor from what I recall.
Okay.
The biggest I remember is the last one I recall was she goes to a yes/no verbal response. Other than that, I don't recall anything else. Just so I'm clear, sir, you're asking me about the medical records.
Yeah.
Okay, thank you.
Yeah, that's what that is.
Yeah,
The
I
things
just want to make sure I was answering the right question.
You are. The things that Ms. Romans had provided, some of the other things that you that I received in discovery that I think that you collected from part of the investigation. So, and each of the Murray children that you spoke with, each one said individually they by themselves were not strong enough to lift their mother. Is that correct?
Correct.
Okay.
Yes.
They both also mentioned, independently of one another, they both mentioned their mother possibly having osteoporosis. You recall that?
I don't remember specifically osteoporosis. I think Michael Murray mentioned bone density problems.
Okay.
I don't know if he was referring to osteoporosis. I don't recall him saying that.
Okay.
I don't recall him using that word, but he could have.
Now, in the interview we heard a little while ago, Karen Murray, she did reference.
She did reference. Okay.
All right, we need a break. We'll get that, and then we're going to be joined by Matt Johnson. We're switching gears to Karen Reed.
12 hours. This jury has been out. What have they said today? Anything? We'll hear that from Matt Johnson next. to Court TV Live. I'm Julia Janae along with Ted Rollins, and we are on a verdict watch here at Court TV in the high-profile murder trial for Karen Read. This jury has been deliberating over her fate for 12 hours.
Now we're just entering into, in the next few minutes, there's our fan dutifully turning as it has been now for 31 plus days of testimony and now our deliberation. We're entering that hour period where the court has told jurors, listen, if you come to a verdict or if you have a question, don't bother telling us until 2 o'clock Eastern, because the judge is allowing the parties to go get lunch, basically leave the courthouse area, leave that so they don't have to report right there. They can they all know nothing will happen in the next hour between 1 p.m. and 2 p.m. Eastern time. Doesn't mean the jury's not still working. It's just that we won't find out if they come to a conclusion and or have a question.
It gives everyone there at the courthouse a chance to take a break, not be on standby, like our Matt Johnson, who is standing by for us. He's spending his lunch break with us. We're going to join him out there in Dedham, Massachusetts in just a moment. But in Tennessee, siblings Karen and Michael Murray are on trial, accused of murder and aggravated neglect in the death of their mother, Sheila. The state is expected to rest its case in chief today, and then we could find out if either of these defendants are going to be taking the stand.
We're also monitoring Idaho, where a hearing is set for murder suspect Bryan Kohberger. That will be beginning actually at any moment. The hearing is going to address a number of things, including scheduling changes as well as some outstanding pretrial motions. Kohberger, of course, is accused of murdering 4 University of Idaho students back in November of 2022. We'll monitor that and have updates later throughout the day here on Court TV.
But let's get back to those deliberations in the Karen Read trial. Joining us now, Court TV crime and justice correspondent Matt Johnson. Matt, what has it been like at the courthouse today? Did we hear anything from this jury, perhaps that didn't go on the record inside of that courtroom?
Julia, Ted, good afternoon. Very tense here at this courthouse here behind me outside of Boston, Massachusetts. You have supporters not too far from here cheering every time they see the defense team and Karen Read. Inside, we have not heard from this jury today. Yesterday, they submitted 2 questions, including wanting more evidence and also scheduling issue. Today, we are being told that the attorneys and Karen Read are being required to be within 5 minutes of the courthouse, just in case there is any news, any questions, or a verdict reached. But we're in that 1-hour lunch break of radio silence from all court staff. If a verdict or a question comes to be, we will not hear about it until 2 o'clock. But earlier during this trial, we have spoken to this defendant quite a bit, which makes this trial very unique. You have her out on bail. She walks with her attorneys each and every day, not taking questions during deliberations, but here's what she told me just the other day. You said that it's hard not to be outspoken, you know?
Very.
And you also mentioned to the media that there are some things that you wish that you could clarify. Is there any?
They'll be clarified one day, Matt. They'll be clarified. It might not be live, but it will be.
One last question. Do you think life can ever be normal again for you?
It'll be different, but it'll be more settled than it is now. It'll never be the same, but it isn't for anybody ever in anyone's life.
Again, she is waiting along with the rest of us, but she's the one facing life behind bars if convicted of second-degree murder. Now, inside the courthouse, I have seen her with her parents. It appeared that they were praying at one point in time. They huddle in the hallways, and they hold hands quite a bit during this waiting game.
Going through a lot, as does every defendant. During this, you know, the attorneys are on pins and needles. But defendants, boy, they really go through it because their life is going to be altered one way or another when the jury comes back. What about the supporters, Matt? Have they been growing? Are they swelling, reducing a little bit here now on day 3? Because a lot of people were out yesterday.
Leading up to the trial, we saw it go from dozens to hundreds of people. On the day of closing arguments a couple days ago, there was upwards of 400 supporters, 200 feet away from the courthouse steps. Yesterday, it seemed to be a little bit less, and once again, a little bit less today. But I'm told by the supporters that they are staying diehard, and they plan to be here through verdict and afterwards if need be. I spoke with a few supporters earlier today, just a couple minutes ago. Take a listen.
I live in Canton, and I know a lot of the people involved in stuff, and it's horrible because some of them were friends before, and now nobody talks to us because they think we're the bad guys. They told us that, they didn't do it, and they're not part of it. Well, I said, okay then, so why get mad at me?
So I have my puppets of the major players. So I've got Karen, I've got Trooper Paul, Jen, Proctor, and Auntie Bev. And I've got Jackson and Yannetti in my purse right here. This is my first day here. I think the mood is great. Everybody seems energetic and excited and hoping for a verdict today, so we're staying positive. Well, it's just been such a wild case, and so being from here, I've followed it from the get-go, and I was like, I got to be there, I got to support, and just be out here to support Karen. I've been glued to the trial for so long. Right, so we've got her trial coming up next, but it's definitely going to be boring. We're just hoping for the right outcome for Karen.
What if it's not the outcome that you're hoping?
Well, then we'll be here to support her for when she appeals and anything else that might happen.
So they're tuned in to Court TV right now. They're waiting for any updates. Remember, this is another reason why this trial is so different. It's not only divided the community, and there are so many people following it across the country, this particular trial, but no members of the public were allowed in during testimony because it was moved to that smaller courtroom. So there's only 10 spots for media. We have a spot once again today. So if there is any movement in the courtroom, I'll be in there and I'll be able to bring you that reaction.
400 people out there, Matt Johnson. Thank you for that update.
I wish Matt could interview all 400 because the ones that we've heard from today are doozies.
Talking to a lot of them.
I could watch that all day long.
Matt Johnson, thanks so much. We'll let you get back inside of that courtroom. Let's bring in our guest who's standing by. Joining us this hour, civil and trial attorney Ted Spalding is with us. Ted, have you seen anything like that many people outside of a courthouse? And do you think that that should have played into the question of whether or not this jury should be sequestered? They are not.
Yeah, I mean, the answer is yes to both. What this immediately reminds me of is back in the day, O.J. Simpson. Remember all the people outside the courthouse watching, waiting to hear what the verdict was going to be. It has a little bit of that to it. And of course, a lot of it is because of the evidence that has been presented. I mean, this case is massive drama. And
is represented by Mr. Thompson and Ms. Jennings, Latah County Prosecutor's Office, and Mr. Nye and Ms. Beatty are participating over Zoom remotely. So we're here for a scheduling order, and I think we're about 13 months from the arraignment. And I think at this point, this is my opinion, that we're getting to a point of diminishing returns. And I sent to counsel last Friday on a proposed scheduling order for a lot of things, deadlines, including setting the trial. And so I also have set this hearing so that we can discuss this and see kind of where everybody is. So let me start with the state. Thanks.
Thank you, Your Honor. We've reviewed the court's proposed scheduling order with the attorney team, and we are agreeable to it. It makes sense that we do the trial in the summertime when high school is out across the street and when the university is out and the conflicting activities. And the schedule that Your Honor proposes is acceptable to the state. I would note just a minor detail that June 19th is also a legal holiday. The court specified July 4th as a legal holiday. We wouldn't be able to hold trial, but
sure,
19th as well. Other than that, we have no objection to the court's proposal.
All right, thank you. I mean, as I went through all of this, I mean, there's going to be a lot of motions, a lot of hearings, a lot of work. There already has been a significant amount of work, as we all know. And when I tried to balance this out, I do think it's pretty fair, balanced, and I hope realistic. So, Ms. Taylor.
Thank you, Judge. Your Honor, first, I know the court has listed this as taking place in Latah County. We haven't been heard on our change of venue yet. That's to come.
Totally understand
August.
that.
So I don't want anybody thinking I'm agreeing to Latah County is all. The June of 2025, that's the time frame that we have been working towards. I am hopeful that we can come in there. We're working towards that date. I think it's reasonable to set that date. As the court's aware, mitigation is something that takes a significant amount of time. We've had that underway since the day we took this case. We continue to work that very hard. I spoke with our mitigation expert last night about this date. And there's a lot of work yet to be done, but we're still working towards that. So I think it's reasonable to set that. I just want the court to know that that's not finished at this point. That's very much ongoing, and new things are coming out that we need to follow up. But with that said, I think it's reasonable to go ahead and pick the June of 2025 as a trial date at this time.
And by the way, I think you understand that, all counsel understand that, but this is a 3-month trial. So I was calculating 2 weeks to set the jury, then 8 weeks of trial, and then 2 weeks for mitigation and sentencing. And I mean, that's a guess, but I think it's enough time for all of those things to take care of. And obviously, the last 2 weeks would only be if Mr. Popper was convicted. Okay, go ahead.
Thank you, Your Honor. I do want to bring up a couple of issues I have with some of the deadlines. I looked this over. Our team has talked about it. I've gone over this with Mr. Koberger. I do have a couple of concerns about the deadlines, and I'll just bring those up to the court for the court's consideration. As far as motions challenging the death penalty, and that's in right under motion practice letter A that the court has on its draft, we can have a lot of those filed by September 5th. I would note for the court that that's ahead of the state's final discovery date, and that's ahead of the state's deadline to produce its aggravation case that it will use. We can meet this September 5th deadline, but we're going to ask the court to give us a little leeway when there's something new that comes our way. If there's an amendment to a motion or a new motion that becomes relevant based on something new, we'd like a 2-week window after receiving something new to file that. But the bulk of it we can get in by the deadline that the court has asked here, and that's just not a problem.
Sure, I understand that. I mean, I looked at that. I wanted to have that early because, you know, it's a bigger question.
Yeah.
And I was aware of the Ross case. I think you had 16 motions in that case. So I wanted to sort of address those issues early.
Your Honor, we can definitely do that. We can address a lot of things early. We just don't want to be precluded from bringing an amended motion or a new motion if something new is filed that would have been relevant to something we've already filed.
I'm not going to prevent you from doing that.
Perfect, thank you.
And by the way, a lot of these deadlines, I mean, you can certainly do them earlier if you'd like to. I would encourage everybody to do that. Thank you.
Your Honor, then moving on, the motions in limine under letter C, the court has suggested February 13th as the date for that. I think in large part we can do some by then, but the exhibits that we'll exchange and witness lists that we'll exchange aren't due until after that. And again, I think there might be additional motions that would be relevant after those things have been exchanged. So if the court wanted to move the whole deadline, so we had all of those motions in limine at once, I think that would be reasonable. But if the court wants to keep this deadline, as long as we have the ability to bring more motions in limine based on new filings, we'll be okay with that as well.
Sure. And I was also thinking about, I guess experts, for example, I mean, they may have longer hearings that, we're going to have to work through all of these things. I mean, this is just a structure.
Thank you. The court had listed March 14th as a trial brief date, and that is ahead of some of the other deadlines, recognizing that the trial is the innocence phase and the sentencing phase, if it happens, is the mitigation and aggravation. I would just say this is a fine deadline, but we won't be touching anything to do with our mitigation by then, if that's what the court anticipated.
Yes.
Okay, perfect.
I think we had March 3rd for mitigation. I figured by then you would pretty much have that in hand.
We hope to. That brings me to the last point I wanted to talk about. The court has proposed setting a mutual exchange of aggravation and mitigation materials, and I'd ask the court to reconsider that. We will aim for our March 3rd deadline. That's our plan right now. If something changes that, then we'll come back and let the court know and talk to counsel. But would ask that the state's aggravation package be provided to us earlier than the same day as our mitigation. Should we get to that point, the state has the burden of establishing the statutory aggravators. There are some things I think I might be able to guess about how the state's going to try to present information, but I don't think I should have to guess. I think I should have that information well ahead of providing the mitigation that will be presented in response to any aggravating information that's presented by the state. So I'd ask the court to set the date for the state to produce its information much earlier than ours. The state filed its notice a year ago yesterday, and I have a lot of questions about what the state would intend to use to try to establish many of the statutory aggravators they've listed. I know I've heard the court talk about super due process in a capital case, and I think it's appropriate for us to be on notice and be provided discovery, to be provided a full range of what the state intends to use to establish those if we ever get to that point. And I think we need those ahead of our deadline for mitigation. So I'd ask the court to move that deadline up quite a bit earlier. And that's it.
Thank you very much. Mr. Thompson, do you have any issues about having the aggravation in advance for a period of time?
No, sir. As long as we will have the option, the ability to supplement that once we see whatever the defense plans to offer in the way of mitigation.
Well, I'm appreciating that, with these deadlines, that we're going to have supplement all the way along. I just don't want to be scrambling around a month before the trial. We're all going to be very, very busy. And the more we can resolve certain motions, supplements, whatever we need to do, I'm trying to do this sooner than later.
Yes, sir. And that's our preference as well.
And Ms. Taylor as well.
Yes, Your Honor.
But just to make sure, though, I mean, you have to do your job, and the state has to do its job, and I have to do my job. But I think this is a great step, okay, to set these deadlines and hearings so that we can move through this. It's going to take a while, but anything else we need to address today, Mr. Thompson?
I don't believe so. Thank you.
Ms. Taylor?
No, Your Honor, thank you.
Okay, well, it's very short, and I'm grateful that everybody's working together. Thank you. Okay. Take care, everybody. We are adjourned.
All right.
All right, Agent Pritchard, I think that's all the questions I have. Thank you. Sure.
Mr. Donaldson, cross-examination.
Good morning, Agent Pritchard.
Good morning, sir. I'm fine. How are you?
I'm good. I'd kind of like to go chronologically through the statement that you took from Michael Murray.
Yes, sir.
Right from the beginning, you called him into the room, is that correct?
I did.
And this was on August the 30th of 2019?
Correct.
And that was how many days after you began researching and working on this case? It was
17 days.
17 days. Was it 3 days after Miss Murray died that you got involved in this?
Yes, yeah.
Okay.
3 to 4.
So if she died on the 15th, you got involved on the 18th of August?
Thereabouts. Yeah, the The request for investigation was signed by General Baldwin, I think on the 13th of August.
And you introduced yourself to Mr. Murray, Michael Murray.
Yes.
That was the first thing at the interview. You offered your condolences for his loss of his mother. Is that correct?
I did.
Okay. You also explained to him why you and your organization were involved in this case. Is that correct?
That's correct.
You stated that anytime anybody goes to the hospital who's that age, who's that fragile, it is something that needs to be investigated. Is that correct?
That is, yes.
Okay. And you also stated the reason that your organization specifically was because of Edwin Murray's long time working in the Johnson City Police Department. Is that correct?
As was conveyed to me by General Baldwin at the time.
Right.
Yes, he had had a meeting with Johnson City PD.
Yes, and the people in the Johnson City Police Department, they were just not comfortable with asking these kind of questions that you would have to ask of either Edwin Murray or his children. Is that correct?
As was conveyed to me by General Baldwin, yes.
Okay. So that was why you were there. And you just said you wanted to get some information from Michael, correct?
Correct.
And you, at about 4 minutes into this interview, you really got into it. You started by saying, it's my understanding that you and your sister pretty much take care of your mom, correct?
Yes, I do recall that.
And then, at about 4:18, you do ask him, can you tell us what is an average day like?
I do recall saying that, yes.
Okay. And just an ordinary day of taking care of your mom. And if I say anything incorrectly, let me know. But what Michael said to you, as I have it written down in my notes, is he said that he would get up at 9 or 10 in the morning, but his sister Karen was usually up and she took care of the medications before he got up. Is that correct?
Yes.
Okay. And he also talked about, and I have to admit that sometimes he used kind of strange words I wouldn't necessarily expect, but he said, when I would go out in town, at different times and then there was a particular avenue, I guess, in Johnson City that was mentioned. Do you remember that? No?
No, I don't.
Okay.
I recall when I'd asked for his address.
Mm-hmm.
Is that when you're talking about it the first?
No, that was just the general. You were talking about the Watauga Avenue. That was at the beginning of the interview.
Yes, that was when I was getting the index information. He had added the word avenue onto the street name, but
1405 Watauga Avenue.
I recall that. I recall him saying avenue there.
Right.
Yeah,
okay. But he mentioned another avenue later on in the thing, but he would say if he went out of the house, basically was what he was saying.
Okay, well, to answer your question, I don't recall in that part of the interview, I don't recall him using the word avenue.
Okay. You don't recall that?
I do not.
Okay. But he did say that if he left the house, and if he was out, that she would stay. You remember that?
I do remember that, yes.
And when he said that, did you take it that he was talking about his sister?
As the person that was staying with his mother while he was out? Yes, I did, yes.
Okay. All right. And if the sister ever had to go out, he told you that he would be there. Is that correct?
Yes, that's correct.
And there was always someone that was there with her constantly. Is
Correct.
that right?
Correct.
And he did mention that from time to time, the dad was there.
Yes.
And if they weren't there, the dad was there. Is that right?
I can't say I recall him saying that exactly.
Okay, maybe not exactly, but do you remember any conversation that you had with him where he said, there was always one of us that was there?
I do recall that. Yes, I do recall that part.
Okay, and then I have in my notes that you talked.
Yes, I recall that.
Okay, but she got to the point that she.
All right, have a little issue with the feed there. Let's get a break, iron that out, and then we also have some news coming out of Idaho, that Kohlberger hearing that is going on as we speak. We're monitoring that, and when we come back, we'll share some news from that hearing. Stay with us. Welcome back. A little breaking news out of the state of Idaho. A trial date has now been set for murder suspect Bryan Kohberger. All the parties have agreed to a June 2025 trial date. And this, of course, has been... The family's been very frustrated. It's been a year and a half and still no trial dates. That's gone back and forth, and now here we go. During this hearing going on right now, a trial date has been set.
All right, let's go into court for that moment there in the Latah County Courthouse.
Thank you, Judge. Your Honor, first, I know the court has listed this as taking place in Latah County. We haven't been heard on our change of venue yet. That's to come in August. So I don't want anybody thinking I'm agreeing to Latah County is all. The June of 2025, that's the time frame that we have been working towards. I am hopeful that we can come in there. We're working towards that date. I think it's reasonable to set that date. As the court's aware, mitigation is something that takes a significant amount of time. We've had that underway since the day we took this case. We continue to work that very hard. I spoke with our mitigation expert last night about this date. And there's a lot of work yet to be done, but we're still working towards that. So I think it's reasonable to set that. I just want the court to know that that's not finished at this point. That's very much ongoing, and new things are coming out that we need to follow up. But with that said, I think it's reasonable to go ahead and pick the June of 2025 as a trial date at this time.
And by the way, I think you understand that, all counsel understand that, but this is a 3-month trial. So I was calculating 2 weeks to set the jury, then 8 weeks of trial, and then 2 weeks for mitigation and sentencing. And I mean, that's a guess, but I think it's enough time for all of those things to take care of. And obviously, the last 2 weeks would only be if Mr. Kohberger was convicted. Okay, go ahead.
Thank you, Your Honor. I do want to bring up a couple of issues I have with some of the deadlines. I looked this over. Our team has talked about it. I've gone over this with Mr. Kohberger. I do have a couple of concerns about the deadlines, and I'll just bring those up to the court for the court's consideration. As far as motions challenging the death penalty, and that's in right under...
All right, there you have it, June 2025 as the trial date for this trial that's so anticipated by so many people. November 2022 was when these 4 lives were taken. The suspect there inside of the courtroom. 3 months long this trial is expected to be. 2 weeks of jury selection, 8 weeks for the trial, and if there's a conviction, 2 weeks for that penalty phase. Let's bring back in Ted Spalding, who is standing by. Ted, your thoughts on that change of venue that's still pending? The trial date doesn't really impact that. The defense attorney wanted to make sure, hey, we're not agreeing to staying here in Latah County, where the college is that these 4 students attended.
Yeah, I like that. That was the hint, hint, judge, let's get a ruling way of presenting that to the court to remind them, because clearly she wasn't waiving that by agreeing to the trial date. I am very interested for the ruling on that change of venue. Change of venue is brought up by motion a lot in high-profile cases. It's rarely granted from what I've seen, and there's been plenty that I look back at and say, this is probably one that should be granted, and then it's not. So it would be rare that it's granted in this case, but you know what we were talking about is we have a small town, very high-profile case. Would that be enough in and of itself? Then, of course, we've got this unique survey that is being allowed to try to generate the evidence to show to the judge that, look, everybody is biased. We cannot get a fair trial for the defendant here in this county. Thought that was a very interesting strategy for the defense, as it's been reported on, because you're always worried, are you biasing the jury against your own client if you don't win the motion and the people that got this survey are now on your jury. So all of this is very, very interesting. They're putting all their the defense, their eggs in that basket. They want this venue changed. They really do believe that their client is not going to get a fair shake if they must move forward now what looks like June of 2025 with the trial here in this venue.
And all parties in a death case have in the back of their mind the automatic appeals that go along with the death penalty in this country. And if you are sentenced to death, you are afforded, at the cost of the government, appeals, and it can go all the way, it will go all the way to the Supreme Court of the United States. So the change of venue is a big one in that, let's face it, it may, at the end of the day, if he and they don't change the venue, that's number one. And the defense is doing a very good job of making it very clear. They're pushing and talking and making the record very clear. We want to change a venue. This is a college town, a small college town, and 4 college students were killed. This hit home in this community like no other conceivable case you could come up with in terms of how it affected a community. Because the university is so intricate within the community. I don't know, Ted, your thoughts on the judge, factoring that in, even the state, if you're going to go for the death penalty, you have to take that into account, correct?
Yes, and quite frankly, both sides, right? Either side can appeal. So just as much if the ruling is not changing venue, what if the ruling is change venue? And then there's an acquittal. The other side, prosecution, could appeal, say that was not a good decision by the judge. So there's concerns on all sides, but yes, judges always, rightfully so, are concerned about their rulings and can they be appealed. Defense is always trying to create as many avenues to an appeal as possible. This is ultimately one of them that is used, is changing venue in a high-profile case like this. So smart on the part of the defense. The question, again, for trial strategy is, do they go too far in wanting to build all of these building blocks to a good appeal if venue is not transferred? That is what we'll see when the trial actually occurs.
If he's acquitted, there's no appeal from
Right, no appeals for the state. They can't go back and do anything. But we do, just thinking about an appeal in this case, because overwhelmingly people believe the evidence is there. And my question, I know, Ted, you've talked about this Boise, Idaho versus where they want to move it, a bigger city, the capital of Idaho versus Latah County. I feel like the court is going to have to address how he would be prejudiced in Boise when everyone knows about this case. To your point, people there are more intimately impacted by it. They were the ones who didn't know who did this horrible crime. It's been all this time, these college kids are dead, and they perhaps feel a different way about it. But in Boise, Idaho, I don't know that it's any different for him in terms of people who know about the case. I think there's more that the defense would have to show, that there's a safety issue or something about staying in Latah County, especially in the summer when there's going to be perhaps some more room in this college town because kids will be on summer break.
Yeah, I get what you're saying is that Boise's not, Manhattan or New York City. There's a collective consciousness there that is very aware of this. And that's what the state's arguing. This what everybody argues in every one of these cases. But the jury pool is 10 times, 20 times of what it is. This is why the Daybell case was moved to Boise for the same reason. Chad Daybell is sentenced to death. And guess what? Change of venue is not going to be part of his appeal because they changed the venue. It's a pain in the butt. It costs a lot of money for local taxpayers. But it takes that away. And at the end of the day, if you want a death sentence against somebody and you want it to stand up, change of venue is a big one, especially in a huge case like this. And this is 10 times bigger than Daybell, right?
For sure. For sure. When we talk about the country and their attention on this, I'm not sure about the impact to that local area because everyone was looking for the kids in the Daybell case, so many people knew about it there as well. But We're, of course, going to continue to follow every development out of that Latah County, Idaho case. We will, of course, keep an eye on the change of venue when the judge makes the decision on that. But meanwhile, we are in a verdict watch in Karen Reed's case there in Massachusetts. And we're going to get you back to testimony in Tennessee in the trial for the brother and sister who are accused in the death of their mother. Stay with us. You're watching Court TV Live.
Tonight on Closing Arguments, our verdict watch continues in the case against Karen Reed. We'll break down what could be having the biggest impact on this jury as deliberations continue.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Friday nights, the WNBA is on Ion. This week, Brian has a dream of blocking out Dejanay in the sun. Then, can Lexi and the Sparks rise above Diana and the Mercury? Coverage starts Friday night at 7. Ion, it's on.
His action was just to pull out the revolver, and it went off.
Two people accidentally shot.
Alec Baldwin was the actor on set. Alec Baldwin? Yes, sir.
Hurry, hurry, hurry was the motto on the set.
Right away, let's reload.
Alec Baldwin claims he didn't pull the trigger. Well, the FBI disagrees.
It's not going to fire until you pull the trigger.
They really do have to show that he couldn't care less.
The case against Alec Baldwin premieres Sunday, 9/8 Central on Court TV.
of Karen Reed is in the hands of a jury. We are in a verdict watch in the killer or cover-up murder trial in Dedham, Massachusetts. The jury has been added for 12 hours, 54 minutes, and in about 15 minutes, if they have a note that they've gotten in the last hour, if they have a question or a verdict, then they will inform the court. Round 2:10, we should know whether or not they have something waiting.
The blackout window ends at 2 o'clock Eastern, and then if nothing happens, we continue to wait. They're expected to go till about 4 o'clock again, I think, today. But it's varied, and the judge has allowed the jury to be in control of deliberations. No browbeating, get back there and work till midnight.
They can
not
go till
here.
5 if they want.
Yeah, and then go home. And not a let's not stay up till midnight. While we wait, we've also been watching testimony out of this other very interesting trial in Tennessee, the brother and sister murder trial. The defendants there, Karen and Michael Murray, are charged with first-degree murder and aggravated neglect in the death of their mother, Sheila.
They face a potential life sentence if they are convicted on that top count of first-degree murder, life without parole. Let's go back together now to this testimony on the stand. We are watching Agent Brian Pritchard. He's under cross-examination by the defense.
Least the last week of her life, she said that she was not talking much. Is that correct?
The last week. I'm gonna have to say I don't recall. I would have to refer back to the interview on that one. I don't know if he was addressing that particular concept, or lack of a better word, was addressed with two variations of time. One was a week and the other was a few days, and I don't recall which one that applies to.
Okay. Do you recall him saying that she really got quiet in the bed?
Yes.
Okay. And do you recall that he said if we would give her dinner at the end of the day?
I recall the dinner. That's the only meal that I recall being mentioned.
Right. And do you recall him saying that we would sit her up and we would get her to the restroom?
Yes.
Okay. Now, you say that you were an EMT, correct?
Long time ago.
Okay. A long time ago I was too.
Okay.
Back in 1990. But you are aware there are certain carries that a person can get somebody up if one person is standing on the right side of a person and one person is standing on the left side of a person. Is that correct?
Correct.
Where you take an arm and it goes behind that person, not the person in the middle, but one arm goes around the person on the right, and one arm goes around the person on the left.
Correct.
Right.
Yes.
And so if they took Miss Murray to the end of the bed and then did that, could they get her off that bed?
In my earlier testimony, I based that statement on the decubitus and the necrotic tissue that I observed in photographs. I based that on Karen's testimony that she was drawn. And they couldn't, I also saw in medical records where hospital staff could not undraw the hands. That's what I based that belief that there was no way that could have happened the day before. I mean, that she was not gotten up the day before. That's what I based that on.
All right.
So with your description of a fireman's carry, I think it's quasi-fireman's carry. I don't know how they could have done that.
Okay. Do you remember Mr. Murray saying things to you about his mother was not traveling much anymore?
I do, yes.
Okay. Like I said, sometimes did he say some things that didn't quite make sense?
I don't recall anything inappropriate. The text that you just gave, it was followed up by she was in a wheelchair at some point, and he met her at the airport, or yeah, he met her at the airport while she was in a wheelchair. I can't say that was inappropriate. I mean, it related to what we were talking about loosely, but it related.
Okay.
So I don't know how to answer your question, sir.
Well, my question is this. In dealing with Mr. Murray, did you ever get an impression that Mr. Murray might be somewhat simple?
No. He was appropriate. I mean, there was context to most of his answers. Sometimes loose, but there seemed to be context. I don't know how to define that word, sir.
Okay.
Simple. I don't know if my definition of that word is the same as yours.
Okay. But you did think that some of the things that he said was a little bit off?
No.
Not at all?
No, I'm going to say not at all. There was context. There was context to the. It wasn't always quite the question I asked,
Okay.
but I can reference other parts of the interview that it was just, if there was something he didn't know or didn't recall, I call it running down a rabbit hole, but it didn't really answer the question, but it provided an answer. It certainly wasn't the question that I'd asked, but it provided an answer.
Okay.
Okay, we're going to get a break, but if you look at the deliberations clock, it's just hit 13 hours. Ted Spaulding, final word on Karen Read. What does 13 hours tell you? What do you think?
Nothing's changed. I think, again, at best, in my opinion, they're debating between charges. What lesser included ones, there's probably a holdout or two, would be the thought process. But anything can happen. It still could be a full guilty verdict. It could be an acquittal. So it's going to be really interesting.
There are many options for this jury. We will see if after 2:10 we hear something more from them during this blackout time they've had for the lunch break. Again, that verdict watch continues, but also that testimony in the Tennessee trial for the brother and sister accused in the death of their mother. Stay with us. We have a lot more ahead, and we could get a verdict today. Before 3:45 is when they'll get a note.
We've seen, just when you're lulled into it, the fan stops and there's a verdict. But for now, it keeps turning and they keep deliberating.
Welcome back to Court TV Live. I'm Julia Janae. Thank you for following along with us this afternoon as we are watching two major trials here today at Court TV. We are in Massachusetts. Day 3 of deliberations are underway in the trial against Karen Read. She faces life in prison if found guilty of the 2022 murder of her Boston police officer boyfriend, John O'Keefe. That jury's been deliberating for 13 hours and 6 minutes. They deliberated through their lunch today and will, of course, take you inside of that courtroom if we hear that the jury has a question or a verdict. We are also following the brother and sister murder trial in Tennessee, where two siblings, Karen and Michael Murray, are charged with the murder and neglect of their own mother, Sheila Murray. So let's pick up the testimony right where we left off. We've been hearing from an agent on the stand, Brian Pritchard. He's talking about how he questioned Michael Murray and whether or not he thought that perhaps he wasn't very advanced, simple. These are the words that the defense attorney is saying in the cross-examination of this agent trying to dispel the idea that their clients were murderers.
The routine was they would get her up and they would put her on the bedside potty. Is that right?
Yes, sir.
Okay. Now, you talked about you got involved in this case 3 days after Miss Murray died.
3 or 4.
3 or 4,
Yeah.
right? And would you agree with me that you want to look at everything in the case before you talk to a potential defendant?
Everything I can get my hands on. I mean, at the time, and I don't know that I don't know that either were defendants at that time. I mean,
Well, a person you're going to interview.
My contention for that interview was I was interviewing a witness, a potential witness.
Potential witness.
I don't think I treated them as a subject at any time.
Okay. But if they're going to say something, you want to know as much about the case as you can know. Is that right?
Oh, correct. Yes, sir. Yes, sir.
Okay.
I want to know if I'm being lied to or not.
Okay. And did you have, at that time, did you see any statements from any EMTs or paramedics?
I had.
And did you see, or in those statements or in your conversation with them, did they talk to you about feces and urine and things like that?
Yes, sir.
Okay. So was there ever anyone that, shortly after the 10th of August, did anybody go into that house to confirm as to whether that toilet had been used by Mrs. Murray?
Not to my knowledge.
Okay. Would that be a way that you could confirm or rule out that statement by him?
The statement by who?
By Michael Murray, that they put her on that toilet so that she could go to the bathroom.
That would be a way, yes.
Okay. All right. Now, the injury that you are most concerned about is the ankle injury. Is that correct?
No.
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 I was concerned with all the injuries.
Okay. You were concerned with all injuries, but wasn't it the sepsis from the ankle that was the cause of death here?
According to the pathology, yes.
Okay. And you wanted to know as much about that as you could. Is that correct?
That's correct.
So you talked to the defendant about that. Is that correct?
Yes.
You talked to Mr. Murray about
Yes.
that. And he told you that on the day that the ambulance was called, he had pulled back the sheet. Is that correct?
I recall that phrase, yes.
And he told you that that was the first time he had seen the bone. Is that correct?
I recall him saying it was the first time he saw her leg.
Her leg.
That he had been talking to, he'd been talking to Karen, asking her is she okay? Is everything okay? And the reply was yes.
Okay. And he also stated that it was wrapped up tight. Is that correct?
That's correct.
But on this particular day, the day that they called the ambulance, he pulled back the sheet and saw what he saw.
I don't recall him elaborating after he pulled back the sheet. I don't think he described any blood on the gauze or anything like that.
Well,
I would have to go back and listen to that again.
It says, I pulled off the cover and saw her foot. Do you remember him saying that?
Yes. I don't recall anything after that.
And therefore, we can't take her to the toilet.
Yes.
Because
okay.
of what he
I do
saw.
recall that. Yes. Yes.
We need to call 911.
Yes.
He said that. Okay.
I can't confirm the order, but I do remember those phrases individually or together.
And he talked about the fact that it had previously been wrapped up and it was not like that. Is that correct?
Is that verbatim?
Well, that's my notes. We had it wrapped up. It was not like that.
I recall that, yes.
Okay. And he told you that prior to that, he had never seen a bone sticking out.
I recall that. Are we still going in chronological as far as the interview goes?
Yes, sir.
Okay. So that phrase would have been after. That phrase
Yes.
would have been after he moved the sheet.
That he said that was the first time he had seen the bone. Yes.
That phrase was after he said he moved the sheet. I'm not trying to be difficult. I just
He moved the sheet and saw her ankle, saw the bone.
yes.
Okay.
Yes, I do recall that.
Therefore, we can't take her to the commode. We need to call 911.
Correct.
Okay. So that was his reaction the first time he saw that. Would you agree with me on that?
I do.
Okay. Now, he did talk to you about earlier, he thought she had a bruise on her ankle. Is that correct?
I don't recall him referring to the bruise on the ankle. I recall a bruise to the back when we're talking about the decubitus. I don't recall a bruise on the ankle.
Okay. But you do recall that he did say that it was wrapped up.
I recall the wrap, yes.
Mr. Dawson, I think we'll break at this point so the jury can go over and have their lunch. Sorry to interrupt, but I don't want it to get into the lunch hour where their food is getting ready to come out before they get there. All right.
All right, a break there in the feed that we have been watching. Let's bring in our guest who is in studio today, trial attorney and former president of the National Bar Association, C.K. Hoffler is here. C.K., it's so great to see you in person here in studio. Let's talk about this case. It's such a difficult one. And the cross-examination by this defense attorney is really getting into something I think people are thinking when they are watching these defendants at the defense table. They're asking if this investigator picked up on Michael Murray perhaps not understanding things very well. They used the word simple. They asked, did you think he was a little slow? Did he not really get it? And this investigator is saying, no, he's seen, though he may have taken his time getting to an answer, he gave context, he was able to share things. That's huge in a case like this, do you think, when it comes to murder charges?
Absolutely. Because of the charges, their mental state, their mens rea, which is we say the legal terminology, what they intended to do, they had to formulate the intent to commit this crime, the intent. And I just don't think, just based on my observation of these two defendants, there is something cognitively, it appears to the naked eye, so I can only imagine what the jurors are thinking, but it appears that they are having difficulty and some of the testimony with cognitive sense. circumstances. Perhaps, and I don't want to label or characterize anyone inappropriately, but that's just based on what I see. So I think that they're overstretching in terms of the charges, because I think maybe negligence, yes, some type of negligence charge, but not aggravated, where you have to have the mens rea, the intent to harm, and certainly they didn't intend to murder their mother. I just don't think there's evidence of that. I don't think they're going to be able to present any evidence of that. So I think it's on people's minds. You can look at them. When I look at the film and the footage of the daughter, even her presentation, and the son certainly. Now, they've been incarcerated for some time, which is another issue. But I just think that they really have certain issues with cognitive skills.
I think that's a great word to use. We're not quite hearing it inside of the courtroom. We'll see if we have anyone on the stand who can talk about the psychology behind it, but I'm not sure because it hasn't come out. Not sure if the state was able to keep it out because of perhaps a motion in limine, because they are fit to stand trial, not legally insane, or they would be making that defense. We do want to get back into the courtroom. We, of course, have been pausing during our coverage of the Karen Read trial, the Bryan Kohberger hearing today, and also during commercial breaks. So we were a bit behind, but now we can pick it up after that lunch break there in the courtroom. Let's go in.
Anyone spoke with you outside the jury panel? And did any other juror try to speak with any juror about this case? No? All right, we're ready to continue with the cross-examination of Agent Pritchard by Mr. Donaldson on behalf of Mr. Michael Murray.
Mr. Pritchard, you spoke to several people on that day when you spoke to Michael. Is that correct? You talked to all three. You talked to the father, the daughter, and the son. Is that correct?
That's correct.
Okay, so you spoke to Karen Murray before you spoke to Michael Murray. Is that correct?
The only thing I could remember for sure is that I spoke with Edwin first. I don't remember the order of the other two. Okay. I testified to that earlier.
But you do recall when you talked to Karen, she did tell you that her brother had mental problems. Is that correct?
I do recall that, yes, sir.
Okay. And she also stated because of those mental problems, he had to take medications. Is that right?
Yes.
And those medications oftentimes would cause him to sleep at some time past noon. Is that correct?
I do recall, yes, sir.
Okay. Were you able to verify that?
I was not.
Okay. Thank you. That's all the questions I have.
All right, redirect.
I'm going to start with Michael Murray since the last one that we just talked about. Again, when did Michael Murray tell you that the last time that they had gotten Mrs. Murray up to clean her was?
Best I recall, he had said it was the day before the 911 call on the 10th, so I'm going to say August the 9th.
Okay. And do you remember him saying in that in the course of that interview that they had let her lay in bed for a couple of days and then they decided to get her up on the 10th? He didn't use the day the 10th, but on the 10th would have been the 10th.
He did say that, yes.
Okay. Which would have meant that she wouldn't have been up on the 9th, correct?
Correct.
And with regard to, you've been asked questions about the idea that, where you said she wouldn't have been able to put pressure on her foot.
Yes.
Miss Murray, and because of the decubitus, that would be painful for her.
Yes.
All right, we're hitting the pause button on this testimony. We do have to squeeze in a break. We'll get you back in for more of this trial in Tennessee against the Murray siblings. And we're also watching that clock in the Karen Read trial. 13 hours and 20 minutes. This jury has been out. Stay with us.
The action was just to pull out the revolver, and it went off.
Two people accidentally shot.
Alec Baldwin was the actor on set. Alec Baldwin? Yes, sir.
Hurry, hurry, hurry was the motto on the set.
Right away, let's reload.
Alec Baldwin claims he didn't pull the trigger. Well, the FBI disagrees.
It's not going to fire until you pull the trigger.
They really do have to show that he couldn't care less.
The case against Alec Baldwin premieres Sunday, 9/8 Central on Court TV.
back to Court TV Live. Before we get you back into the courtroom in Tennessee, we have a quick update on another story that we have been following, the birthday murder case against Marcella Chidester. She's accused of driving her car into a boat club that killed 2 children at a birthday party earlier this year. Now, a probable cause hearing has been going on today. It's going to go on for 2 days, and it will determine if there's enough evidence to move forward with those charges and to a trial for the 66-year-old woman, Marcella Chidester. Prosecutors claim that she was under the influence of alcohol at the time. The crash killed 2 siblings, a 4-year-old and an 8-year-old. Over a dozen others were injured in that collision. Now, the defense has said that she was suffering from a seizure at the time. Earlier today, the prosecution played surveillance video of the crash for the judge, as well as the body camera of Chidester speaking to the police afterwards.
On a scale of 0 to 10, 0 being like you're stone cold sober, you can drive perfectly, 10 being you're passed out drunk, where do you think you're at right now?
7.
A 7? Okay. Do you think you're okay to drive?
I wouldn't want to drive.
They wouldn't let you drive?
No.
Okay.
We will bring you more updates on this hearing later on Court TV. For now, though, let's get you back inside of the courtroom in the brother and sister murder trial in Tennessee. Prosecutors say there that the siblings, Karen and Michael Murray, are responsible for abuse and neglect that resulted in the death of their mother, Sheila, back in 2019, and they're charged with first-degree murder. Let's go back in now to hear more from Special Agent Brian Pritchard. He's under cross-examination by the defense.
Remember Karen Murray talking about how when her and Michael Murray, they one on each side, vice versa, they get up, and then she would have to get down and move the feet, get off the bed and get down and reposition her mother's feet so she'd be turned the right. And to you, is that indicative that they were putting pressure, she was standing up for them to move her feet?
That would be my assumption, yes.
Okay. Make sure. And initially, do you recall Miss Murray telling you that, Miss Karen Murray, telling you that her brother only helped her lift her mother? Remember initially saying that?
I do. Yes, to that effect, yes.
And do you recall her then changing and saying that it was all, excuse me, all 3 of them shared in the responsibilities of cleaning, and doing, taking her to the potty?
Yes.
Okay.
I remember.
And Michael Murray, in his statement, did he also confirm that he assisted in various things?
Yes, he stated all 3.
Okay. And I think Mr. Donaldson was the one that asked you about when Mr. Michael Murray would talk about, you know, sometimes if he had to go out to town, I think is how he said it, that Karen would stay there. He didn't use her name, but that's who we know it to be. Or if Karen needed to go somewhere, he would be there.
Yes.
And the implication of that was that his mother would be left in his care, correct?
Correct.
Okay. So that would mean his family felt okay with leaving him there and leaving her in his care.
That would be my assumption, yes.
No further questions.
Cross, Mr. Gordon, excuse me.
Thank you, Judge. Agent Pritchard, with regard to the technique they used that she described, that General Ray was asking about in terms of getting their mother up out of bed and repositioning the feet, she was talking about that was generally the way they did it, correct?
Best I recall, yes.
Okay.
Yes.
She didn't say specifically that that's how they had done it in the days leading up to August the 10th, 2019, did she?
But I asked for an average day or a typical day, and that was the response.
Okay. Yes. But as far as like, she didn't say this is what we did in these days right before that. She said typically this is how we would do it. She didn't specify that that's what they'd done the days leading up.
Not to my recollection, she didn't.
Okay. And with regards to the comments she made about her brother's mental health and bipolar disorder, all that. I mean, I know you told Mr. Donaldson that you didn't look into that and everything, but did you have any reason to believe that Karen Murray was being untruthful with you about her brother's conditions?
No.
Okay. Nothing further. Thank you.
Recross. Mr. Donaldson.
And Agent Pritchard, when I was talking about the fireman's carry, is that when Michael Murray told you it was their regular routine? When you asked him what was the regular routine, you didn't specify, like it was on the 9th of August. You just said, what was the routine?
Yes, what would a typical day of caring for your mother sound like?
But you didn't mean, when you said that I'm talking about August the 9th.
Not specifically, but I had, in the interview, I had addressed the day before and the day after, or the day of the incident and the day before,
Yeah,
specifically what had happened that day.
But before you got to the specifics, you talked about the normal routine, correct?
Yeah, the general, yes, sir.
And it was at that time that he said, me and Karen, we cleaned her up, we got her up, we took her to the restroom and stuff. We would get her to the end of the bed, and he would be on the right, her sister would be on the left, and they would do ready, 1, 2, 3, and they would help her up.
I do recall to that effect, yes.
Okay. Thank you.
Redirect, General.
None, Your Honor.
All right. Is Agent Pritchard released from his subpoena?
From the state, yes, Your Honor.
That's fine, Your Honor.
All right. You want to retain him as a witness? All right. Agent Pritchard, thank you for your testimony. Appreciate you coming back again today and after lunch.
Agent Pritchard released from testifying. He has been a state witness, and we are expecting the state to rest their case in chief today. Coming up, the state's final witness is taking the stand, the forensic pathologist, Dr. Emily Cook, who would have performed that autopsy on this victim. We'll be right back. Welcome back to Court TV Live. A jury in Dedham, Massachusetts has been deliberating now for 13 hours and 37 minutes in the killer or cover-up murder trial. Karen Read is the defendant there. She faces life in prison if she's found guilty of the 2022 murder of her Boston police officer boyfriend, John O'Keefe. You see there a live look inside of the courtroom. The ceiling fan has been going. It's a hot day there in the Boston area, and we will take you there into that courtroom if the jury comes back with a question or a verdict. But so far, mum's the word inside of that courtroom. We haven't heard anything from this jury. Yesterday, they did have one question that was substantive about wanting a particular search report. While we wait to hear something from that jury, let's head back to Tennessee for the brother and sister murder trial. The defendants there are Karen Murray and Michael Murray. 68-year-old Sheila Murray was their mother. She was hospitalized on August 10th, 2019, after paramedics found her in bed, covered with bed sores and with a bone sticking out of her leg. She died from complications at the hospital, but the horrific state that she was found in eventually led to the arrest of her two adult children, 43-year-old Michael and 49-year-old Karen Murray. Now they're standing trial, charged with first-degree murder of their mother. Let's get you back into court now. The state's final witness is taking to the stand Dr. Emily Cook. She performed Sheila Murray's autopsy.
Can you spell that for us? It's a little different spelling, I think.
E-M-I-L-I-E.
Thank you. And last name?
Cook, C-O-O-K.
Thank you, Dr. Cook. You may ask General Laws.
Thank you, Your Honor. Dr. Cook, where do you work? I work at ETSU at the William L. Jenkins Forensic Center.
How long have you worked there?
It will be 5 years in July.
And what do you do at the William L. Jenkins Forensic Center?
I am a medical examiner and a associate program director for the pathology residents.
Tell us what your duties are as a forensic pathologist.
So we will accept cases, we accept jurisdiction on all unnatural deaths, anything that's suspicious, anything, unnatural. So we do autopsies or external exams on those cases to figure out cause and manner of death.
Is there a particular area of Northeast Tennessee that you accept cases from?
We do the 8 counties up in like our triangle of Eastern Tennessee.
Were you working at the Forensic Center or Medical Examiner's Office on August 16th of 2019?
Yes.
Are you a licensed physician here in the state of Tennessee?
Yes.
How long?
I believe over 5 years at this point.
Is your license current and in good standing?
Yes.
Please tell us about your educational background.
I have a bachelor's in science from Tennessee Tech in Cookeville, Tennessee. I went to medical school at DeBuss College of Osteopathic Medicine in Harrogate, Tennessee. I did 4 years of pathology residency training here at ETSU, and then I did a 1-year forensic fellowship at Wake Forest in Winston-Salem.
Do you have any special certifications or specialties?
I'm board certified in anatomic pathology, clinical pathology, and forensic pathology.
Do you belong to any professional associations or organizations?
I'm a member of the National Association of Medical Examiners, so it's kind of our big society for the medical examiner system, and also a disaster mortuary relief team.
I'm going to pass a document up to you.
Thank you.
Do you recognize that, Dr. Cook?
Yes.
What is that?
My CV or resume.
Is it current?
Yes.
Your Honor, I ask that be admitted as the next numbered exhibit.
All right, that is our curriculum vitae or vitae, however we say it.
CV.
CV, that's better. Resume. All right. The document identified by Dr. Cook as the curriculum vitae for her experience will be marked and moved into evidence as Exhibit 18.
Dr. Cook, what is forensic pathology?
It is basically the study of how people die. So what our main goal or job is to figure out the cause and manner of death. As I said, most of the cases that we take are going to be unnatural or unexpected. So basically the end point of what we are going to do is figure out what happened to the person.
You told us that part of your duties as a forensic pathologist is to perform autopsies. Is that correct?
Yes.
What is an autopsy?
So it's a postmortem exam. We'll start with what we call the external. So we identify the decedent, make sure we have the right person. We will look over their entire body. We'll document their eye color, hair color, scars, tattoos, anything along those lines. We will then look for injuries. We'll document all the injuries that we find. And after we complete the external exam, we'll then, if it's a full autopsy, we will then do a Y incision and eviscerate, which means we will take out all the organs and examine those too to evaluate for natural disease, any trauma, or any other thing that we may see that may be unusual.
How many autopsies do you think you've performed in your time as a forensic pathologist?
Over 1,100 at this point.
Have you been qualified as an expert witness in forensic pathology before?
Yes.
Here in Washington County?
Yes, ma'am.
Your Honor, I tender Dr. Cook as an expert in forensic pathology.
No objection, I understand. All right, by stipulation and without objection, Dr. Cook is declared an expert witness in the field of forensic pathology. Her testimony will be viewed in that light. Thank you.
Thank you, Your Honor. Dr. Cook, did you perform an autopsy on Sheila Murray on August 16th of 2019?
Yes.
Did you make a report of your findings?
Yes, ma'am.
Would having a copy of that report to look at refresh your recollection and assist you in your testimony this afternoon?
Yes.
Do you have a copy of your report with you?
I have a shortened version. So.
Okay, I said I can pass one up to you.
Thank you.
Does that appear to be a copy of the report that you completed that contains your findings regarding the autopsy of Sheila Murray?
Yes.
I'm going to pass forward. I handed you not a clean copy. It has my highlighter.
Okay.
So I'm going to switch with you. You could take a look at that. Is that a clean copy without my yellow lines of your report?
Yes, it is.
Your Honor, I would ask that Dr. Murray's report be admitted as the next numbered exhibit.
No objection. No. All right. The autopsy report identified by Dr. Cook as the autopsy examination of Sheila Murray will be marked as Exhibit 19 and moved into evidence.
And Your Honor, General Ray has kindly made copies of the autopsy report to provide for the jury to follow along as we go through our testimony.
All right, ladies and gentlemen, you will be provided by the court officer a copy for each of you to follow along. I'll ask you to listen to the testimony, and when Dr. Cook is referencing a particular portion of
We're hitting a pause button on this testimony while they take that break there inside the courtroom to talk about what the Dr. Cook is going to be explaining about the cause of death for Sheila Murray. Let's bring back in trial attorney and former president of the National Bar Association, C.K. Hoffler, is with us. C.K., you mentioned something that I want to highlight where you said poverty plays a big role in a case like this. Tell me why.
Well, what we see a family, they're adult children that are living at home. They're taking care of their mother. Their father at some point was alive. We know that there's evidence that he was alive.
And he died just a few months after she died.
Absolutely. But they did not have the money to be able to put her in an appropriate facility. most significantly, even if you do have access to Medicare or Medicaid, you have to have money to be able to do that transition. And so this is sometimes what happens when you have family members, when you don't have the resources, who are taking care of loved ones. And as I said earlier, I do believe that there might have been some form of impairment where these adult children may not have realized the magnitude of her illness and realized that they were over their heads. That's what I believe happened. But this is the kind of thing that happens when you lack resources. You don't have the ability to go someplace to put someone in an institution that's appropriate, because it takes money to do that. And even if they're state-run institutions, there's a whole process. And so that puts into question the cognitive ability and skills of these adult children. But this is the kind of thing that happens when there's poverty, when there's not access to resources, when there's not access to courts, when there's not access to some of the agencies, and you just don't know how to proceed, and you don't have the money to proceed. You may not have the money for transportation. You may not have the money to call people to galvanize a team to help support your loved one.
I mean, caretakers are unsung heroes. It is not an easy job. It is an everyday job. There are challenges, and this defense wants to show that these two were not prepared for that challenge. Coming up next, Dr. Cook is still going to be continuing her testimony about her report. It will include the graphic autopsy photos of the victim, Sheila Murray. Stay with us.
Tonight on Closing Arguments, our verdict watch continues in the case against Karen Read. We'll break down what could be having the biggest impact on this jury as deliberations continue.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Scripps Newsline is a different kind of nightly news show because some stories really deserve a deeper conversation.
Scripps Newsline, weeknights at 9. Find with an antenna or on your favorite streaming app.
Welcome back to Court TV Live. Before we get you back into that courtroom in Tennessee for the Karen and Michael Murray trial, we have a quick update out of Idaho, where today defendant Bryan Kohberger was back in court. He's accused, of course, in the quadruple murder of University of Idaho students back in 2022. The hearing was brief, but both sides did agree to a trial date, and they set a preliminary timeline for this highly anticipated trial.
We've reviewed the court's proposed scheduling order with the attorney team, and we are agreeable to it. It makes sense that we do the trial in the summertime when high school is out across the street.
The June of 2025, that's the time frame that we have been working towards. I am hopeful that we can come in there. We're working towards that date. I think it's reasonable to set that date. As the court's aware, mitigation is something that takes a significant amount of time. We've had that underway since the day we took this case. We continue to work that very hard. I spoke with our mitigation expert last night about this date. And there's a lot of work yet to be done, but we're still working towards that. So I think it's reasonable to set that. I just want the court to know that that's not finished at this point. That's very much ongoing, and new things are coming out that we need to follow up. But with that said, I think it's reasonable to go ahead and pick the June of 2025 as a trial date at this time.
And by the way, I think you understand that, all counsel understand that, but this is a 3-month trial. So I was calculating 2 weeks to set the jury, then 8 weeks of trial, and then 2 weeks for mitigation and sentencing. And I mean, that's a guess, but I think it's enough time.
Bryan Kohberger is charged with 4 counts of first-degree murder in connection to the fatal stabbings of these 4 University of Idaho students back in November of 2022. And as we know, the family of one of the victims, Kaylee Gonzalez, was also in attendance today, posting this on Facebook earlier today, saying, quote, "Please say a prayer for our family. We are traveling to Moscow for court at 10. Rally the troops," end quote. This is going to be a 3-month trial, according to the judge. About 2 weeks for jury selection, 8 weeks for trial, and they're reserving 2 more weeks if he's convicted for that penalty phase, because this is a death penalty case. Let's get you back now into the courtroom in Tennessee, where Michael and Karen Murray are accused of neglecting their bedridden mother, which prosecutors say ultimately led to the 68-year-old's death. Their defense says that these two were in over their head, but they are not responsible for intentional murder. Right now, we are hearing from the state's last witness, a forensic pathologist who performed the autopsy on the victim, Sheila Murray. Let's pick it up right where we left off.
Dr. Cook, in the upper right-hand corner under the contact information for the Forensic Center, it says there's a case number.
Yes.
What is that?
The case number is assigned for every decedent that is brought to our facility or called in as a death. So in this case, the first number is the year. The second number is the county, which was Washington County, I believe. And the final digits were the case number for the year in this county.
Who is the deceased or decedent listed on the report?
Miss Sheila Murray.
And what was her age at the time of your autopsy?
68.
What date was the autopsy performed?
On August 16th of 2019.
In addition to yourself, were there any other persons present during the autopsy?
Yes, we have an autopsy technician that is there to help with evisceration, and it was Tiffany Gasperson for this case.
In addition to your physical examination or autopsy of Sheila Murray, did you rely on any other information to assist you in evaluating Miss Murray and her cause and manner of death?
Yes, we received hospital records, and then there were also photos from the hospital stay that we were given.
Now, you told us that when you begin your autopsy process, you start with an external exam. Is that correct?
Yes.
You've given us a description about what that entails. Before we start talking specifically about your external examination of Ms. Sheila Murray, in our trial, other witnesses have described an odor associated with Ms. Murray. Did you detect any odor when you received Ms. Murray for your autopsy?
Yes, she had, because of the large decubitus on her back, it was this smell of kind of necrotic or dying tissue, which we noticed as soon as we opened the bag in this case.
Okay. In beginning your external examination, and for the jury following along, I am on page 3 of 7 of your report. Did you observe any evidence of medical intervention?
Yes.
What did you observe?
So her hospital medical intervention, she had a intravenous line or IV in her right femoral vein. A Foley catheter was inserted into her bladder. She had another IV or intravenous line in the back of her right hand. There was a puncture mark on the right wrist. A white bandage was covering the left heel, and the right ankle had an external fixator surrounded with white bandages, and there was a wound vac in place at that time from the hospital.
In observing Ms. Sheila's body condition, would you describe her as well-nourished or malnourished?
She was very frail looking and had loose skin. Something else we look for is kind of the temporal muscle wasting. So I would say she was malnourished, yes.
As you do that external examination, do you use a body diagram to indicate the location of the injuries or wounds that you observe on a body?
Yes.
Did you do that in this case?
Yes.
Do you also document the external injuries and your observation of those injuries with photos?
Yes, we do.
Okay. And for the jury, we are going to be talking about the body diagram. Well, we're going to be referring to, there's not a page number. It would be page 9 is where the body diagram is. Yes, ma'am.
Looks like this page, folks.
When you are doing an external examination, as you said, looking for any kind of injuries, wounds, where do you start? Do you start just with whatever you see, or do you start at the top and work your way down?
Yeah, generally I'll start at the head and neck and just work my way down kind of systematically.
Okay. Let's start with the head and neck. And this is page 4 of your report. Can you tell us what you observed about Miss Murray's head and neck area?
Yes. On the right lateral chin, she had a 1/8 inch red-brown abrasion.
And let's talk about her torso. Did you visualize any evidence of injury on her torso?
Yes.
What did you see?
The right upper chest had an area 2.5 by 1 inch of scattered excoriations and red-brown abrasions.
What's an excoriation?
It's similar to an abrasion or a scratch. I believe in this case, she had a fungal infection, so I think that was the cause of the smaller excoriations that we called.
Okay. What did you observe next?
The right breast had a 4 by 3 inch open necrotic wound with purulent material or pus-like material.
Such difficult testimony from this forensic pathologist. We do have to get to a break. Our thanks to C.K. Hoffler for her legal analysis this hour. Coming up, we've got more testimony there in Tennessee, but we're also watching that Karen Read trial. Matt Johnson's going to join us for a break. Stay with us.
800-956-0122. 800-956-0122. Call now.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you. We are following two major trials today here at Court TV. First in Tennessee, testimonies underway in the trial for the siblings Karen and Michael Murray. They are charged with murder and neglect in the death of their own mother, Sheila. We will take you back into that courtroom in just a moment. But let's begin in Massachusetts, where day 3 of deliberations remain underway in the trial against Karen Reed. She faces life in prison if she is found guilty of the 2022 murder of her Boston police officer boyfriend, John O'Keefe. Here to catch us up on all the latest is our own Court TV crime and justice correspondent, Matt Johnson, live in Dedham, Massachusetts, covering this trial for us. You've been there day in, day out, Matt. Tell us, what's the latest that you are hearing about day 3 of these deliberations?
Well, a couple minutes ago, Judge Ashley, there was a little bit more commotion over at the courthouse, but we have not been told about any questions or any verdict on day 3 of deliberations. Those 6 men and 6 women deciding Karen Reed's fate on day 3 of these deliberations after a trial that spanned over 9 weeks with more than 70 witnesses and evidence. They are working with a different verdict form as of yesterday that includes an updated form for the manslaughter charge. Originally, it just said not guilty after the top charge, but now it's been added to say not guilty of the offense charged or any lesser included offense. Here's that heated moment. There was a heated moment between the defense attorney asking for that of the judge yesterday to make that change, and then a couple hours later, she came back with this response. Take a listen.
I considered what you said. I went back and I read the jury instructions I gave yesterday. So I do appreciate the concern about the confusion this might cause the jury. I think it's easily clarified with the supplemental instruction. I don't think it's the verdict slip. I think it's how they're to follow the verdict slip.
Your Honor, may I be heard?
Yes.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip that says the 2 words, not guilty. We would ask that the verdict slip read, not guilty of the offense charged or any lesser included offense.
Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
And both defendant Karen Reed and her attorneys, along with the O'Keefe family, they get led in and out of the courthouse separately at different times with state police. And they are also not in the courthouse during these deliberations, but they are told, Judge Ashley, to be within 5 minutes.
All right, we know it's 14 hours, 9 minutes of deliberations. Tell us, Matt, what is the mood like at the courthouse, around the courthouse, as we're waiting?
Yeah, people are watching this trial around the globe. There are some news outlets here as far away as Germany that are doing reports here, and there's documentary crews. There's a lot of media, growing number of media as we enter day 3 of deliberations. As for the supporters, on closing arguments in the beginning of those deliberations, we saw about 400 supporters wearing pink and T-shirts that said "Free Karen Reed" and holding signs and cheering for the defendant. Yesterday, we saw fewer less, and then today we're seeing dozens of people, maybe upwards of 100. We've been speaking to supporters all day during these deliberations, and here's what some told us. Take a listen.
Depending on the verdict, we're going to celebrate because it's going to bring truth and it's going to expose. But even if the verdict is not what we think it is, it's bringing truth to light. And that's more important for people to have their eyes woken up to what's really going on in different systems.
I live in Canton, and I know a lot of the people involved and stuff, and it's horrible because they're all, some of them were friends before, and now nobody talks to us because they think we're the bad guys. They told us that, you know, they didn't do it and they're not part of it. Well, I said, okay then, so why get mad at me?
So I have my puppets of the major players. So I've got Karen, I've got Trooper Paul, Jen, Proctor, and Auntie Beth. Oh, yeah. And I've got Jackson and Yannetti in my purse right here. This is my first day here. I mean, I think the mood is great. Everybody seems energetic and excited and hoping for a verdict today, so we're staying positive. Well, it's just been such a wild case, and so being from here, I followed it from the get-go, and I was like, I got to be there, I got to support, and just be out here to support Karen. I've been glued to the trial for so long. Right? So we've got her trial coming up next, but it's definitely going to be boring. We're just hoping for the right outcome for Karen.
What if it's not the outcome that you're hoping?
Well, then we'll be here to support her for, you know, for when she appeals and anything else that might happen.
Again, those supporters say that they'll be here till the very end. These diehard supporters that we've seen out in front of the courthouse steps in the cold and the snow during a heat wave, and now during this long verdict watch.
All right. Thank you so much, Matt. We appreciate you standing by and letting us know when something happens in that courtroom. Next, I'd like to welcome trial attorney, family law attorney Michelle Thomas. Michelle, this is a case in which I've said since the beginning, I suspect that wouldn't be surprising for a hung jury because the nation is divided. People either believe, yes, she hit him in some form or fashion, intoxicated intentionally or not, or on the other hand, they believe the defense, there was a conspiracy, something else happened to him, she's not criminally responsible. What are you thinking as we are now looking at 14 plus hours, day 3 of deliberations?
Good afternoon, Judge Ashley, and thank you for having me. This is really one for the books. When you're looking at 14 hours, I mean, it seems that a hung jury is imminent at this point, but it seems to me that there's probably just 1 or 2 holdouts, because if it was more evenly divided in the jury room, then they probably would have conceded to a hung jury by this point. So I think that we're now looking at 14 hours with them trying to convince 1 or 2 more people to side with them. The problem here is that there were strong arguments on both sides, both for the state. When you look at Karen Reed's demeanor, her consumption of alcohol, her the voicemails that she left, and just a lot of unexplained answers. But then on the defense side, there is arguably reasonable doubt. Michael Proctor was a serious problem for the state. So there are arguments on both sides, and here we are 14 hours later, still waiting.
We are still waiting. Of course, we'll bring everyone any updates as we receive them. You're going to stand by because we want to turn back now to court in Tennessee, where we are hearing from the forensic pathologist who performed victim Sheila Murray's autopsy. Let's go back in.
Had a 6 by 5 inch area of dried abrasion and skin breakdown up to 2.5 inches in greatest dimension.
When you talk about a 6 by 5 inch area of dried abrasion, is that 6 inches long, 5 inches wide? What are those dimensions?
Yes. So, okay. Yes.
And the 2.5 inches, what does that measure?
That was an area within the 6 by 5 inch area that was particularly broken down. So the skin was thinner in that area.
Okay. Continuing down the torso, what did you observe next?
On the right lower quadrant of the abdomen, there was a 3.5 by 1.5 inch area of linear excoriated abrasions. So more of those like scratch-like injuries.
And lastly, what did you observe on the torso?
The right posterior back in the area of the right scapula was a 5.5 by 4 inch area of ulcerated open necrotic tissue extending down to the bone. The area of ulceration had a depth of at least 1/2 inch.
When you say in the back, in the area of the right scapula, where's that?
So it's just gonna be your right upper back. And you can see it on the diagram, specifically where it was.
Okay. And you said ulcerated open necrotic tissue. What does ulcerated mean?
The tissue in this, where it was so necrotic, was just kind of broken down at that area, like eaten away.
And what is necrotic tissue?
It would be dead or dying tissue.
You told us that this open wound essentially extended down to the bone.
Yes.
So is it fair to say this wound went through her skin, her fat, and her muscle?
Yes.
Many layers.
Yes.
I'm going to pass up to you what has been marked and admitted as Exhibit 6.
Thank you.
Do you recognize the person in that photo?
Yes.
And who is that?
Miss Sheila Murray.
In looking at that photo, are you able to point out to the jury some of the injuries that you have just described for us?
Yes.
If you could hold the picture towards the jury and just indicate what we're seeing here.
So this this area here, kind of around or underneath her left breast, was one of the areas of dried abrasion that I spoke about. Some of these other smaller areas were just small red abrasions or that excoriation. She had a pretty diffuse fungal infection when she was in the hospital, so that's what some of those little areas are from. You can also see the very loose skin that I described, her ribs sticking out up at the top, and the temporal muscle wasting on the side of her head is just kind of a sign of malnutrition.
In this photo, can you point out to us where the red-brown abrasion on her right lateral chin was located?
It may be a little hard to see in this, but it should be over off to this side of her chin.
I'm going to pass up to you what has been previously marked and admitted as Exhibit 11. You mentioned that she had some fungus on her body. In this photo, which has been described as the area basically under Miss Murray's neck, chin onto her neck area, are we able to visualize some of that fungus that you observed?
Yes. So this was in the hospital. So this was, I believe, prior to getting any treatment. And you can see the area right here, that red area is where the fungal infection was very prominent. It was slightly lessened when I saw her because she had had multiple days of treatment in the hospital, but it's pretty severe in this picture.
In looking at that picture in the lower left-hand corner, it looks like there is some redness or some type of wound there. What are we seeing a portion of in that part of the picture?
Yeah, it looks like a small abrasion, but I can't exactly be sure.
Okay.
The reality of hearing about the results of the autopsy, hard details to listen to, but accusation of murder in this case. So let's take a break. When we come back, we're going to hit that pause button. We'll get you back inside for more from the forensic pathologist.
Tonight on Closing Arguments, our verdict watch continues in the case against Karen Read. We'll break down what could be having the biggest impact on this jury as deliberations continue.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
We're in the final stretch as the case against Karen Read nears its end. Plus, Friday, hear from the loved ones left behind with a voice for victims.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
we head back to court in Tennessee, a quick update out of Florida, where defendant Ashley Benefield is back in court today for a motions hearing. The former ballerina is expected to go to trial next month for the 2020 shooting death of her estranged husband, Doug, amid a bitter custody dispute. Benefield claims that she shot in self-defense during a domestic argument, but police say no, there is no evidence to support that theory. That motions hearing is expected to get underway at any moment, so we'll bring you any updates later on today. But now let's get back to the brother and sister murder trial underway for siblings Karen and Michael Murray. Prosecutors say the two are responsible for the neglect of their mother, Sheila, who ultimately died after being admitted into the hospital back in August of 2019. On the stand now, it's the forensic pathologist who performed Sheila's autopsy, direct examination by the state. Let's get you back into court.
A open necrotic wound containing
purulent.
Thank you. What is that?
It's pus, or what you would expect if you have an infected wound, the white material that is generally seen with infection.
I'm going to pass up to you what has been marked and admitted as Exhibit 9A. What are we looking at in that photo?
This is Miss Murray's right breast. You can see all of this tissue here is necrotic, and that white fluid is purulent material, and I believe in the hospital they said she had an abscess there as well, so a collection of pus.
Can you tell us, on a wound like this that we see on Miss Murray, how does a wound like that progress?
When you have a pressure ulcer or anything like this, if the person is not getting moved, that can progress it pretty quickly. If they're exposed to moisture, wet environment, or anything like that, it can progress the injuries pretty quickly. Not cleaning it obviously would progress it quickly.
Are wounds like this painful?
Yes, I would think so. Obviously, the areas that are necrotic are dead, but any of the areas surrounding it would be painful.
All right, let's move to Miss Murray's upper extremities. Did you see evidence of injury in her upper extremities?
Yes. In the upper extremities, the right elbow, there was a 1.5 by 1/2 inch area of superficial skin breakdown. The left elbow had 4 skin erosions ranging from 1/2 inch to 1 inch in greatest dimension, with surrounding skin breakdown. The right posterior hand, on the second digit, there was a circular area that was 3/8 of an inch of skin breakdown and a 1/8 inch abrasion. The right posterior third finger, there was a 3/8 inch abrasion. The right posterior fifth finger had a 1/2 inch abrasion and 2 1/8 inch abrasions. The left posterior third finger had a 1/2 inch abrasion. The left posterior fourth finger had a 1/4 inch abrasion, and the left posterior fifth finger had a 1/4 inch abrasion.
When you say skin breakdown, what does that mean?
If it's early on, the tissue will just be red and kind of thinned. It's the start of what you would see in a bed sore. So it's kind of what I would describe as an early stage.
When you talk about the left or right posterior of the hand, where is that?
So that's going to be on the back side of your hand. When we do our body diagrams, it's in anatomic position, so the posterior hand is going to be on this side.
Dr. Cook, I'm going to hand up a photo to you that we have printed in black and white. Do you recognize what you see in that photo?
Yes.
And what are we looking at there?
This is the backside of Miss Murray. This was a photo that was taken at our morgue. It has our case label here, so I can identify it as being done at our facility. You can see this is the deep wound that was on her right scapula, so the right upper back. She also had some of those wounds on her buttock, like superior buttock area. The elbows had areas of skin breakdown as well.
And Your Honor, we do have copies of that particular photo. I would ask that it be admitted as the next numbered exhibit and with permission to publish that to the jury.
All right. That will be marked and introduced into evidence as Exhibit 20.
I'm going to.
Okay.
In looking at that photo that we've just gone through, and once it's marked, if we could return it back to Dr. Cook. Oh, she's got it. I think they just handed it to her. Thank you. In looking at that photo, Dr. Cook, you had described to us when we were talking about the torso area that the right posterior back in the area of the right scapula has a 5.5 by 4 inch area of ulcerated open necrotic tissue extending to the bone.
Yes.
Are we able to see that particular injury in this photo?
Yes, it's up here, kind of in the right upper corner of the photo on her right upper back.
I'm going to pass up to you what has been previously marked, and if you could just hold on to that photo, we're going to go back to it.
Okay.
What has been marked and admitted as Exhibit 13A.
Thank you.
What are we seeing in that photo?
This is the area on her right scapula, so the right upper back. This was taken at the hospital. So this still has all the necrotic tissue there. I believe it was debrided at the hospital where they go in and try to remove some of the dead tissue to help with healing. But it's just a better visualization than the black and white photo to show you the size of it.
In looking at that photo, first of all, we see around the edges of that wound, the skin appears to be very red.
Yes.
What is that an indication of?
So that is kind of what I would describe as that early tissue breakdown. So this wound probably started in the center and then continues to extend out. So without treatment, it's just going to keep growing and extending out into that light red tissue.
As we go in from that red ring around the wound, we see what looks to be like whitish or yellow tinged material. What is that?
So I think just from the photo, it looks like it's the start of some of that necrotic tissue. It looks like there may be a little bit of that purulent material in there as well.
Where do we see the necrotic tissue?
Specifically in that central area, that is a good example of the necrotic or dead tissue. And it looks like in this picture, you can see it going down at least through the fibrous tissue.
Is that a wound that would be painful?
Yes.
Now, you told us that you not only measured the length and width of that wound, you also measured, to the best of your ability, the depth of that wound.
Yes.
I want to pass up a photo to you. This has also been printed in black and white.
Thank you.
And just off
Just a reminder, although the jury is looking at photos of the injuries being described, those are too graphic for us to show. We need to take a break. We're hitting the pause button. When we come back, we'll get you back inside for more of the direct examination. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for being with us. We are following new developments out of Georgia. A search is underway for two missing firefighters. Chandler Kubander and female firefighter Reagan Anderson are missing, along with a 2017 Ford Focus. Kubander's family last heard from him yesterday, and they do not believe that Kubander left willingly. Police believe they are headed to the Gatlinburg Pigeon Forge area, and there are reports that the pair might have been involved involved in a relationship. Online records show that Anderson was recently arrested for vandalism and then released. Of course, we'll keep you posted on any new developments. Now let's turn back to Tennessee for the brother-sister murder trial. Karen and Michael Murray are accused of neglecting their mother, which prosecutors say ultimately resulted in her death. But the defense says the Murray siblings were simply in over their heads when it came to taking care of their ailing mother. Let's get you back into court now where the state's final witnesses on the stand, Dr. Cook, a forensic pathologist who performed victim Sheila Murray's autopsy.
Your examination and measuring of that wound on the scapula.
Yes. So this photo was taken.
Let me stop you right there. Your Honor, I'd ask that it be admitted as the next exhibit.
All right, the photograph just identified by Dr. Cook will be marked and moved into evidence as Exhibit 21. You have copies to pass to the jury.
Yes, Your Honor. Okay. Tell us what we're looking at in this photo.
So in this photo, we have a photo that was taken in the morgue at the time of autopsy. You can see a little bit deeper than the photo that you just looked at because they had debrided or taken off some of the dead tissue to try to help with healing. So it looks like it goes a little bit deeper here because that dead tissue has been removed. In this area, that's a probe that was used to measure how deep the injury actually goes, and it was measured at least half an inch deep.
And in that photo, we see some sort of, looks like a metal implement of some type. What is that?
That's the metal probe that we use to assess how deep the wound was.
Okay. In talking about the upper extremities, you talked about some injuries to Miss Murray's elbow. Is that correct?
Yes.
Elbows. The right elbow and the left elbow. I'm going to pass up a photo which has been marked and admitted as Exhibit 7. 7. Yes, ma'am. Which was described to us as a photo of Miss Murray's left elbow. Can you indicate to us what injuries that we're seeing in that photo?
Yeah, so on the left elbow, we see that kind of pink-red tissue that is similar to what was surrounding the larger decubitus or bed sore. So this I called skin breakdown, and it's kind of like the early onset of what would become a larger decubitus or bed sore.
I'm passing up a photo to you that hasn't been admitted yet. Thank you. Do you recognize what's in that photo?
Yes.
And what is in that photo?
It looks like the corresponding left elbow photo that was taken at autopsy.
And is that a fair and accurate representation of what you saw at autopsy?
Yes.
Your Honor, I'd ask that be admitted as the next member exhibit.
No objection. Exhibit 22, identified by Dr. Cook, is a photograph of the left elbow of Sheila Murray at autopsy. That will be marked and moved into evidence.
Your Honor, we have copies from the jury to you. First of all, Dr. Cook, in that photo, we see a little card with a number on it. What is that?
That is Miss Murray's case number. So every photo that we take on the case will have that number in it, just as an identifying feature in case anything. We just need to have it tied to her case.
Still with me, trial and family law attorney Michelle Thomas. Michelle, two things I want to speak to you about. The first one is this autopsy report. It's terrible, the sounds of all the injuries to her. What are your thoughts as you know the jury's hearing these details? Oops, I think we lost our guest. I want to share with our viewers while we see if we can get her back, though, the definition of first-degree murder in this particular case. The state of Tennessee is relying on first-degree murder as the killing of another committed during aggravated neglect of an elderly or vulnerable adult. And so then you have to look at that definition. Aggravated neglect of an elderly or vulnerable adult is a caregiver. State is saying that both the son and daughter were caregivers who commit neglect resulting in serious bodily harm. Serious bodily harm obviously did happen. And Michelle, I don't know if you were able to hear for the definition or not, but my question is, listening to these autopsy results, do you think it's enough evidence to say that clearly these two caretakers neglected their mother?
Yeah, and that's what's troubling here is that there is such overwhelming evidence of neglect from a layperson's perspective, just watching it. It sounds horrifying, that the conditions in which their mother died. And that is all that's required is if they can prove that she died while they were committing this aggravated neglect of their mother, then they could in fact be found guilty of first-degree murder, which is, you know, this is a really difficult case because I do not believe that they intended to kill their mother based upon the evidence we've heard so far. We haven't seen anything about, you know, specific intent or an intent or plot to kill their mother. But the level of just the level of neglect that's presented here is problematic. Now, if the defense can show that they were not aware, they were not cognizant of the extent of the neglect, that they were, quote unquote, in over their heads, then they may be able to gain an acquittal here. But it's a very horrifying set of circumstances in which this poor woman ultimately died.
And to me, the question becomes, was there any way that you reasonably could have not noticed the neglect, the things that have been described? If you even walked into the room, it seems like you would notice those things. But the other sister, rather, did testify that 2 weeks before this happened, she went and checked on her mother and didn't notice any of these things. So maybe it happened very quickly. The second thing I'd like to speak to you about is their demeanor, their appearance. They look much younger than they are. The daughter has been more emotional than the son, but I think they present as fairly sad, pitiful, not necessarily able to comprehend everything that's going on. How do you think their demeanor affects the jury?
Oh, I think it's going to have a direct impact because you can see, particularly the daughter, Karen, she's been crying throughout this trial. She suffered the loss and trauma of losing their mother. I understand the father died not that long ago either. And so having to relive and experience what their mother experienced and went through, it's going to affect the children who present as having loved their mother. And so there's a lot of, issues here in terms of how things even got to this point in the background, whether they do have an appreciation mentally for the responsibility that came with caring for their mother, whether they had the resources to get help in caring for their mother and how that affected things. But from a juror's perspective, looking at the condition, those are not crocodile tears. Those are the tears of children, though grown and adult children, who desperately feel a great sense of sadness for what their mother endured, now that they may start to realize what occurred that ultimately led to her demise.
Right. And, are they going to testify or not? I wouldn't expect that they would, but we don't know yet. That's a defense decision that will be made, and ultimately they have to decide if they're going to address the jury or not. All right, stay with me, please, Michelle. We need to take a break. When we come back, we're going to get you back in for more of the brother and sister murder trial in
Jimmy? Hey, Jers. We all appreciate how hard you've been working, and I understand you'd like to stop for the day, so we will certainly do that. We appreciate everything you're doing. I do have to give you those same precautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Clear your heads. We'll see you tomorrow.
Good, all rise. Hurry up. Getting seated.
All right, we'll see everybody tomorrow morning. Thank you.
Thank you. Rise, please.
Hey there, Karen Reed trial watchers. You know what a lot of the trials we cover remind me? It's that you gotta be careful who you surround yourself with.
Karen Reed, the clock is paused. The jury is coming into the courtroom now. Let's see what they have for us.
Hey, Jers. We all appreciate how hard you've been working, and I understand you'd like to stop for the day, so we will certainly do that. We appreciate everything you're doing. I do have to give you those same precautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Clear your heads. We'll see you tomorrow.
Good, all rise. Hurry up.
Still with us, Michelle Thomas. Michelle, I'm not too surprised. It's the end of the day. They tend to sometimes stop a little early, almost 4 o'clock. The jury is going home. But you know what I've been thinking? 14 hours, 50 minutes. It is 30 days of evidence. It's 30 days of information they have to go through. I understand we're having some technical difficulties with Michelle's feed, but I just want to comment, you know, for a jury to go through that much evidence and information, maybe it's not surprising that it's been 3 days of deliberation to figure out what they decide that evidence means. In the meantime, let's go back to Tennessee for the brother and sister murder trial. Michael and Karen Murray are charged with first-degree murder in connection to the 2019 death of their mother. Prosecutors say the Murray siblings neglected to care for the ailing 68-year-old, which ultimately led to her death. Let's go back into court. We've been hitting the pause button. The forensic pathologist who performed Sheila Murray's autopsy is on the stand still under direct examination by the state.
To the hospital photo that you just saw, you can see the redness there that was previously described, kind of that superficial skin breakdown.
I'm going to pass up to you what has already been marked and admitted as Exhibit 10. I talked about some injury on the fingers. What are we looking at there in Exhibit 10?
So this is a photo from the hospital of Miss Murray's fingers, and you can see the start of kind of that central ulceration and the surrounding red tissue there. So that was kind of consistent with the abrasions and injuries that we saw at autopsy.
I'm going to pass up another photograph to you. Can you tell us what that's a photo of?
I believe this is a photo of her posterior, or no, this is of the right elbow and arm. We've got our case number there, and so this area is kind of more of that superficial skin breakdown. Not as bad as the left elbow, but still present there.
Your Honor, I would ask that that be admitted as the next numbered exhibit.
That photograph would be Exhibit 23, marked and moved into evidence.
And which elbow?
That was the right elbow.
Now we've talked about our upper extremities. Let's talk about our lower extremities. Did you see evidence of injury in the lower extremities?
Yes.
And what did you observe on the lower extremities?
On the buttock, there was a 12 by 6 inch area with greater than 20 excoriations, so kind of those smaller abrasions, 1/4 to 2 1/4 inches in greatest dimension with surrounding skin breakdown.
And that is similar to some of the other wounds that you have seen on her upper extremities as well as her torso?
Yes.
Okay. Next.
The right posterior mid-thigh, there was a 3.5 by 1.5 inch area of purple contusion, which is a bruise.
Next.
The right lateral foot had a 1/2 by 1/2 inch area of skin breakdown.
And was there anything else you observed on her right foot?
The right heel had a 1 by 1 inch contusion with surrounding skin breakdown.
What about her left heel?
The left heel had an area of 1 1/4 by 1 inch ulceration with necrotic debris.
What is necrotic debris?
A dead tissue.
And her right ankle?
So the right medial malleolus bone is softened. So that's when you touch your ankle, it would be kind of the circular ball area that's sticking out. That's your medial malleolus, part of your tibia bone. And with our probe and scalpel, it was soft, so you could push into it, meaning that the bone was not intact. So it had infection and was not viable.
As far as her right ankle, there was an external fixator?
Yeah, fixator, I believe.
Fixator,
Yeah.
that would make sense. What is a external fixator?
I believe the orthopedic team put that in place to just set the bones, to put them in the proper alignment for healing.
And you said that there was a wound vac in place. What is
Yes.
a wound vac?
Generally, if there's a large open wound, they will place a wound vac over it to help the tissue secretion, so the blood or any serous fluid from an injury. Sometimes they'll do it with open surgeries on the abdomen, and it just collects the fluid from it.
Did you observe any injuries on her thighs or genital area?
The posterior upper thighs and vulva had erythema without abrasion or laceration.
What is erythema?
So it was just redness. In this case, I would kind of say it was similar to a diaper rash that a child would get.
I'm going to pass up what has been marked and admitted previously as Exhibit 12. What are we looking at in that photo?
This is a picture from the hospital, and this is her right elbow and her buttock area here. So the wounds were a little bit more severe here before she received treatment than in the autopsy photos.
And can you point out those wounds on her buttock that you've described to us?
Yeah, so here on the right elbow is that skin breakdown, and also here on the buttock, it's a little bit superior. Over on the left buttock was the area of the redness and skin breakdown. On her back, you can kind of see some of the smaller red abrasions, so that could be from that fungal infection when she went in.
I'm going to pass up another photo to you. What is that?
We'll bring you more from Tennessee after the break. And here's a live look outside the courthouse in Massachusetts, where the jury was just sent home for the day without reaching a verdict. They've now deliberated for a total of 14 hours and 50 minutes. They'll be back in the morning for more. Stay with us. We'll be right back. welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And we are following testimony in the brother and sister murder trial going on in Tennessee. Prosecutors claim that siblings Karen and Michael Murray are responsible for the abuse and neglect that resulted in the death of their mother, Sheila, in 2019.
Paramedics say the victim was found lying in her bed, wet with urine, fecal matter on her face, and her tibia sticking out of her ankle. We want to get you back inside the courtroom hearing a lot of these details because we're listening to testimony from the forensic pathologist who performed the autopsy of Sheila Murray on direct examination by the state.
Breakdown just superior to her buttock.
Your Honor, if that could be admitted as the next numbered exhibit.
All right, that will be Exhibit 24. That will be marked and moved into evidence.
And in looking at this photo, can you show us where the wounds are on her buttocks?
Yeah, so any of the areas with pallor, that's where the superficial skin has been eroded off. So it's the pinker areas would be that breakdown, and then when you start seeing the white tissue and the red hemorrhagic area, it's a little bit deeper of a wound. It's all consistent with the decubitus or bed sore injuries.
Is this the wound that you measured with the 1/4 of an inch to 2 1/4 inch dimension?
Yes.
All right. So let's talk about Miss Murray's feet. Passing up to you what has been marked and admitted as Exhibit 2. A photo that was described to us as the right foot and ankle. What are we looking at in this photo?
This is her right foot. You can see the long, unkept toenails. There also looks to be some injuries under the second and third toenail bed, at least with blood. There are some areas with a little bit of underlying skin hemorrhage here, and then also a purple discoloration here. This one was also taken in the hospital, so it was before I saw her.
You told us that she had an injury to her heels. I'm going to hand you what has been previously marked and admitted as Exhibit 3. And I believe that is her left heel.
So this is her heel, and you can just see that area. So this is just consistent with a bed sore. And that's not an uncommon place to have the start of something. It's basically going to be over anywhere that you have a bony prominence that's going to come in contact with a firmer surface. So the heel is an area that is not uncommon.
How does a bed sore like this that we're seeing on the feet compare to the bed sores on the buttocks and the scapula?
So these would be a lot earlier stage. They don't have the deadened necrotic tissue in the center. We also look at the depth. So this one didn't go through, I would say, like the muscular layers, or didn't get down all the way to the bone. So this one is obviously not as advanced as the one that was on her right back.
Pass up a photo to you of the right foot. Are we able to see, well, let me back up. Do you recognize that photo?
Yes.
Okay. Is that a photo that was taken at autopsy?
Yes.
And is that of her right foot heel area?
I'm not sure if it's the right or the left, just from the photo.
In looking to the right side of that photo, it looks like there's some metal bars or rods.
Yes, I think this is the left heel.
The left heel. Okay,
Yes.
I apologize. Your Honor, I'd ask that this be admitted as the next numbered exhibit.
All right, the photograph identified by Dr. Cook will be marked and moved into evidence as Exhibit 25. Is that right? Yes. 25. Thank you.
And what are we looking at in terms of injury in that photo?
So this is on the heel. You can see here. It's kind of similar to the previous photo, just in black and white. So the tissue in the middle here was red, and kind of heaped up edges here on the outside, kind of consistent with where a bone would be not moving a lot on a flat surface or fixed surface.
When we talked about the right heel, you told us that there was a 1 by 1 inch purple contusion with surrounding skin breakdown. With our left heel, you described the injury as a 1 1/4 by 1 inch area of ulceration with necrotic debris.
Yes.
Are those two wounds in different stages?
Yeah, so I would say the one that had the necrotic debris and the ulceration would be slightly more advanced. Yeah.
And lastly, I'm going to pass up to you what has been marked and admitted as Exhibit 4. What are we looking at in that photo?
So this is the sole of her foot, and you can see even on the bottom there's an area of tissue irregularity with a little bit of that surrounding red tissue around it.
And does it appear that the toenails have been maintained?
No.
Are they also, like in the previous picture, I believe, of her other foot, long?
Yes, very yellow and thickened. I don't see the injuries on these as I did on the other one, but they're unkept.
Moving from the feet, the last injury that we had discussed was the right ankle that had the external fixator with wound vac in place. I'm going to pass up to you a photo. If you could tell me if you recognize it.
Thank you. Yes.
And what's that a photo of?
So this is a photo of her right ankle. When she came in for autopsy, there was a wound vac placed over that, so it would catch any blood or fluid that was coming out of it post-surgery. The tissue is open here, and this is the area on that bony prominence where the bone was soft underneath. So the bone was infected at this area.
Your Honor, I ask that be admitted as the next numbered exhibit.
That would be Exhibit 26, marked and moved into evidence. The photograph is the right angle described by Dr. Cook.
Dr. Cook, we have talked about bed sores, pressure sores, ulcerated wounds. What is a decubitus ulcer?
So it's just another name for a pressure sore or a bed sore. Basically what happens is you've got tissue and pressure. So it's normally in places, like I said, of bony prominence, so on your buttock or on your scapula, on your heels. And the tissue is going to be pressed against that firm surface, and eventually it loses oxygen and will start to die. The initial stages are that red-pink discoloration, and then the later stages are what you saw on her right scapula, where it went all the way to the bone and there was a lot of like dead necrotic tissue within it.
Can these bed sores, decubitus ulcers, can they be prevented?
Yes, it can be difficult with someone that is immobile, but you would have to move them often, do mobility exercises, make sure that they didn't have dirty surroundings, so especially on the sacrum, urine or feces, make sure that the person was clean. Yeah, and then just making sure that they're moving and getting off of the area, at least for periods of time.
If skin breakdown begins, can that be treated?
Yes, early on, they can do a lot of things. In the hospital, even they'll sometimes put pads on people's heels and on their sacrum just to prevent that skin breakdown.
As if a bed sore, decubitus ulcer is not treated and it continues to progress into the conditions that we see here today, is that something that happens in a few hours, a few days?
Going from that early pink-red tissue to how severe the scapula is would be more than a few days of those conditions.
Did you receive any information on the condition that Miss Sheila Murray was found in?
Yes.
And what information did you receive?
I believe the EMS said that she was found on a bed with crystallized urine as well as feces that had mold on top of it.
Is that information important for you when you make your final determinations?
It was more evidence that she had not been cleaned, so those wounds were not being taken care of appropriately.
Based on your examination of the entire body, both internal and external, within the bounds of reasonable medical certainty, have you formed an opinion concerning the cause of death of Miss Sheila Murray?
Yes.
What was the cause of her death?
We deemed it to be sepsis, which would be an overwhelming infection due to the delayed treatment of her right open tibia and fibula ankle fractures.
Was there a contributing factor to her death?
Yes.
And what is that?
The decubitus ulcers or bed sores were a contributing factor.
When you say it was they were a contributing factor, what does that mean?
It means that it was not the primary reason for her death, but basically you can add it on and it didn't help the situation. So they certainly lowered her immune system and were just more evidence of what was going on.
All right, just a reminder, we're bringing you the testimony in its entirety, and we have learned that the jury has now gone home for the day, but we're going to bring you that testimony. But I just have to say to you, I think that testimony right there, the cause of death, the sepsis due to delayed care of the bone, the tibia sticking out, I think that is the grounds for the aggravated neglect.
It is the grounds for the aggravated neglect, given if the jury buys that they were, in fact, caregivers and had assumed that duty and that she died as a result of neglect. And I agree. The fact that she had that in the bed for that period of time that it caused her death, that clearly makes out the neglect as far as I'm concerned.
I think so, too. Yeah. I absolutely agree with you.
No question. And also, we also learned that the siblings decided not to testify. Right. So as the testimony ended, of course, the question that is asked of the defendants as to whether they want to testify, they answered in the negative. They do not want to testify.
Yes, we are going to take a break now. When we come back again, we're going to bring you the rest of this testimony to hear all the details of what these children did and did not do. Stay tuned.
Tonight on Closing Arguments, our verdict watch continues in the case against Karen Read. We'll break down what could be having the biggest impact on this jury as deliberations continue.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
2 people accidentally shot.
Alec Baldwin was the actor on set. Right away, let's reload.
Alec Baldwin claims he didn't pull the trigger. Well, the FBI disagrees.
The case against Alec Baldwin premieres Sunday, 9/8 Central on Court TV.
All right, folks, we'll get you back to court in just a minute. But first, a quick update on a trial that we've been following out in Michigan. It's the birthday party murder case.
Marcella Chedester is accused of killing 2 children after she drove into a boat club where a kid's birthday party was being held.
Earlier today, a pretrial hearing was held to determine if there was enough evidence to move forward with a trial for Chedester. Now, during that hearing, a surviving victim took the stand to recall the moment that Chedester's car came crashing through the walls. You can see it there in the video.
I was sitting at a table against the back wall where the car entered.
And can you describe the situation prior to the crash?
was a beautiful party. I mean, the mother of the child did an amazing job, and everybody was having a great time. It was just, any 3-year-old would have been happy to have that birthday party.
Do you remember anything about the crash?
Yes.
Can you tell me what you remember about the crash?
I remember hearing a super loud, sounded like an explosion. I remember seeing like white dust, peripheral vision, and I felt something hit my back and push me.
Do you know if you lost consciousness?
I do not.
And were you injured as a result of that crash?
Yes, I was.
Do you know what injuries you sustained?
My pelvis was broken in 6 places. I had internal bleeding. My nose was crushed. I had a hematoma on my right arm. A laceration to my head. And some other things. I can't think of everything else.
The judge ultimately ruled that, yes, there's enough evidence to move forward with a trial and set an arraignment date of July 12th.
All right, back now to the brother and sister murder trial in Tennessee.
Prosecutors say that siblings Karen and Michael Murray are responsible for the abuse and neglect that resulted in the death of their mother, Sheila, in 2019.
All right, let's go pick it back in now for more of the state's final witness.
Yes. And what was your determination?
It was deemed a homicide.
And why did you deem this case a homicide?
Due to the delay in her medical care and unsanitary conditions that she was forced to endure at home, her fractured right lower leg became unviable. The bones became infected, and this infection ultimately led to her death. This is evidence of neglect, which is why the manner was deemed a homicide.
In this case of this fractured right lower leg of that, let me say the official tibia and fibia fracture, the infection of the bone, the dying of the bone, in your words, the leg becoming unviable. Is this something that happens overnight?
No.
Is that hours, or are we talking more like days or weeks?
I would, in my medical opinion, think days.
If Ms. Murray had received medical intervention prior to the progression of these bed sores, of this ankle injury, based on your medical experience, do you believe that she could have potentially been saved?
Yeah, she died due to an infection from the untreated injury and wounds. So I do believe if she had received treatment early on for those wounds and the ankle fracture, that she would not have died from this infection.
As a medical examiner, have you seen injuries similar to Sheila Murray?
Yes.
In this case, you stated in discussing the manner of death that this was clearly a case of neglect by Ms. Murray's caregivers. How does her situation differ, in your opinion, from other cases that you have worked involving elderly patients that have these decubitus ulcers or bed sores?
Yeah, so the decubitus ulcers are not super uncommon, as I said, in patients that are in the nursing home or the hospital or just have any kind of mobility issues. As even in a nursing home where they are being moved, they can still develop. But the fact that these became so advanced to me shows that they were untreated and they were not kept up with, and she wasn't taken for medical treatment.
In this situation, in your opinion, was there one thing that was neglected or many things in the care of Ms. Sheila Murphy?
There were multiple, just with the extensive decubitus, especially the one on the right back, as well as the untreated ankle fracture with the bones sticking out of the leg, kind of all compounding together.
I have no further questions, Your Honor.
All right. Anybody need a break? Everybody good for a little while? All right. Cross-examination, Mr. Byrd.
Thank you, Dr. Cook, when you talk about sepsis, how quickly, just in a general sense, can sepsis develop?
It can develop very quickly depending on the type of bacteria. I'm not exactly sure what her bacterial sepsis was.
You didn't see any signs of like septic shock or anything in her, though, did you?
I did not. I wouldn't be able to see that as easily at autopsy as they could in the hospital.
I want to go over some of the other findings that you had with her, just make sure I understand all these. When you looked at her during the autopsy, you found evidence of, looks like quite a few places of evidence that she had heart disease. Is that right?
Yes, she did have extensive heart disease.
Okay. With some pretty significant blockages in places.
Yes, she had 2 coronary arteries with blockages.
Okay. And abdominal atherosclerosis. I can never get that word right. I hope I got close to it. What is that?
So the abdominal, the aorta runs from around your heart down all the way through your abdomen. In her abdomen, the aorta itself had moderate atherosclerosis, so calcification of that larger vessel.
And she had, it appears she had what looks like a kidney disease. Is that?
She had arterionephrosclerosis, so that is related to hypertension. So that's just when the vessels in the kidneys have changes due to hypertension.
Okay. You also found the evidence that she had had a what would appear to be a stroke at some point in the past?
Yes, she had had an old stroke.
Did it appear as there were changes in the brain that you could see that were? Let me back up and ask you, how did you arrive at that opinion?
There generally, after a stroke, after it has been some time, there will be a color.
Let's bring in National Trial Attorney Michael Jaffer. Michael, is there any opportunity that the jury may not choose to disregard the numerous health conditions, really, that this mother, Sheila, had? The clogged arteries, I mean, all of these different things. Might they feel like, unfortunately, she just was not healthy?
Judge Ashley, I'm glad you brought that up. I think that this witness was a little bit better for the defense than it was for the prosecution, because she just laid out right now why this human being died, right? In Tennessee, proving the aggravated neglect is harder than most states, because in Tennessee, unlike most states, you kind of have to prove intent. The main element in an aggravated neglect in Tennessee says that the caretaker knowingly failed to provide necessary care that caused a death, knowingly, not recklessly. In most states, it's just reckless. And so this witness right here, and I can see the closing argument for the defense attorney now, this woman was on death's door at any moment. She was on death's door. She had a kidney disease. She had hypertension. She had multiple comorbidities. And so my client did not knowingly fail. What were they going to do? Reverse the kidney disease, reverse the hypertension? They couldn't have done that. She was going to die that day or a week later. So I think that this witness on this cross-examination, you can see the attorney being very coy, being very slight. That's what it takes in a situation where a child is charged with the death of a parent. So I think this is so far going good for the defense on the cross-examination.
I'm not so sure, Michael. I will tell you this, though. You're right. Had she died of a heart attack or something else, I think it would have been a much more difficult question as to whether to charge the children based on the condition that she was in. But the testimony was that she died of sepsis because of this broken leg, this broken bone. Someone in that house had to have known about that broken bone. It was obviously wrapped up at various times. I think they're going to try to claim that the bone somehow came through after she hit it. I don't know. I'm not sure if they're going to buy that at that meeting, the jury. So with that being the case, when you talk about the juxtaposition between Karen, who seemed to be more involved in care, and Michael, who was less involved and claimed that the leg was always wrapped up when he saw it, I think there's an argument to be made for him in that sense rather than her.
You're in good company. This is why, so Michael, this is the challenge in this case. This is why 3 investigative bodies had to do investigations, and this is why the prosecution sent this to a grand jury and didn't just sit down and look at the sheet and say, we're going to charge murder 1, because they're charged with murder 1. Murder 1's pretty high. I don't see that. And so 3 investigative bodies, the Tennessee Bureau of Investigation, the local police, and Adult Protective Services, all investigated this crime to look into exactly what you're saying. And the boy, I mean, we all know when 2 people are in charge, no one's in charge. And so at the end of the day, I could see that also having playing a factor is it wasn't me, it was you, or it wasn't me, it was you. So like, this is very tough. This is a very jarring case. It's probably among the most difficult cases to prove as a prosecutor because of the fact that like the leg was wrapped up. I thought my sister was taking care of it. It's tough. I just don't, I think in Tennessee, the burden is high. And I just don't see how they're going to show that either of these kids knowingly took an affirmative act or an affirmative act of neglect that caused the mom to die. I just don't see it.
And could this have been tried as 2 separate trials, one for each defendant? Yeah. Theoretically, yes. We don't know if the defense argued that and the judge ruled against it. On the other hand, maybe the defense said no, they want to be tried together. We just don't know.
Yeah, because it's clear that Michael is kind of saying, look, it was really not me. He's not necessarily saying it was her, right. But he's saying it wasn't me because I didn't assume those duties.
I agree.
You have to assume those duties. Yeah. All right, we'll take a break. When we come back, we'll have much more from that courtroom. Keep it here on Court TV, your front row seat to justice.
Welcome back to Court TV. I'm Ashley Wilcott here with Michael Ayala, and we'd like to turn now back to Tennessee for the brother and sister murder trial.
68-year-old Sheila Murray was hospitalized on August 10th, 2019 after paramedics found her covered in bed sores with a bone sticking out of her leg.
Murray died from complications at the hospital, but the horrific state she was found in eventually led to the arrest of her own 2 adult children, Michael and Karen Murray. Now they stand charged with first-degree murder of their mother.
All right, let's get back into court now, where the state's final witness is on the stand, Dr. Emil Cook, who performed Sheila Murray's autopsy. Let's go back in.
Also an area of atrophy where the tissue will almost start breaking down. So she had that in the right internal capsule and left basal ganglia. So she had a stroke on each side of her brain.
Could you tell could you tell the age of either?
No, just that they were older, so they weren't a acute or a new stroke.
Okay. What are those the areas of the brain that you saw those in? What do those involve?
Generally, those areas are the most common places that you will have a stroke with hypertension, so an elevated blood pressure.
Okay. What do they control, those parts of the brain?
Oh, I could not tell you off the top of my head right now. I'm sorry.
All right. She also had fluid in her lungs, is that correct?
Yes.
Okay. Would you expect that to be with the condition of her heart and the heart disease and everything? Is that consistent with the fluid in her lungs being consistent with her heart disease?
It can be. She also, just being in the hospital for multiple days, generally people with a lot of intravenous or IV fluid will get kind of fluid overloaded. So it's not uncommon for us to see people that have fluid buildup after being in the hospital for that many days.
Now, when you get someone that you have to examine, clearly, I would say it'd be extremely rare for you to know anything about the person before they came before you. Is that fair to say?
Our investigators will go out, especially in Washington County, and do scene investigation if they die at home. And we also will generally have at least a brief synopsis of the case before we would start doing the autopsy.
What I mean is before something involves your office, I mean, you don't have any prior knowledge typically of the people before, someone dies and they have to come, there's an autopsy performed. You don't know anything about them.
No, we are only contacted after someone dies.
Okay. And clearly, I mean, obviously you're not going out to the scenes where stuff happens. That's not part of your job.
Not mine, no. Our investigative team does that.
Okay. So your account of environmental, like you've testified some to opinion on environmental factors and everything on this is what other people are relaying to you about like an environment that a person is in. Is that fair to say?
Yes, it was from the EMS and hospital records.
Okay. And along those lines, when you talk about in this signs of malnourishment, you didn't know, I guess, specifically with Mrs. Murray, what her capabilities were prior to death in terms of her ability to eat or to take in nourishment. I mean, you don't know anything about that, do you?
I do not. Basically, we'll just go off of physical findings as far as malnourishment. There could be multiple causes that someone could be malnourished.
Now, when you talk about the ulcers developing, you said that a moist environment can exacerbate that?
It can, specifically in the buttock and genital area.
Okay. If an environment if moisture in conjunction with like a warmer environment, does that exacerbate it even more so, or does it make a difference?
I would think so, but I honestly would just be speculating there.
You think bacteria would grow quicker in a warmer climate?
Yes.
Or climate. Do you know anything about contractures?
Yes.
Okay. What are contractures?
Generally, when I think of it, the first thing that would come to mind would be an elderly person in the nursing home. Their joints will kind of start contracting in, if you will, and it's from immobility. So you'll see it a lot in people that aren't mobile, And to avoid it, you really have to do a lot of mobility exercises and get them moving, or the tissue will kind of just start folding up and they will lose their muscle and mobility.
Did you observe those with Mrs. Murray?
I don't recall. I know it was mentioned in the record, but I don't think I saw that at autopsy.
Okay. If the injury that you described with her right breast with the infection, and looking at the photos of her, if her arms were contracted over that, they would have covered up her right breast. Is that fair to say?
It's possible.
Okay. The contractures, have you ever had to deal with those whenever someone comes to you for an examination?
Yeah, generally, especially in an elderly person like that, if they died at the nursing home, they would come straight to us versus where she was in the hospital. So it may have been a different picture that I saw versus when she first went into the hospital.
Okay. I'm saying just in a general sense of you've dealt with those before, though.
Yes, I have seen them before, yes.
Are they difficult, even post-mortem, are they difficult to get the arms away from the body at that point?
Well, it could be kind of confusing because when you die, you also have rigor mortis. So, yeah, it would be kind of hard to separate the two.
Okay. So that kind of hard for you to tell, how difficult it would be when the person was still living, I suppose.
Right. Yeah.
Okay. You said that the bed sores can be difficult to treat with a person who is immobile. Is that correct?
Correct.
Okay. And you mentioned that in a hospital that they put on what sort of pads? What was that they?
They're kind of just almost like a foam larger bandage. They'll put them over the heels and over the buttock area, and that's just kind of to relieve pressure because those areas are very susceptible to the bed sores.
Okay, so in hospitals, nursing homes, that's a pretty common way to treat bed sores?
We do see a lot of it. It's more preventative, but yeah, we'll see a lot of that.
All right. Now, with regard to your ultimate opinion, what you talked about due to delay in medical care, unsanitary conditions, the decedent was forced to endure at home. Again, that is something what you were basing off what you're told by someone else, right?
Cross-examination continues. We need to squeeze in a break. We'll hit the pause button. When we come back, we'll get you back into court.
Tonight on Closing Arguments, our verdict watch continues in the case against Karen Read. We'll break down what could be having the biggest impact on this jury as deliberations continue.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
A-list actor Alec Baldwin is cast in the real-life role he never wanted.
My jury comes to the gun goes off.
Criminal defendant.
The Alec Baldwin manslaughter trial, coming this July, only on Court TV.
Back to Tennessee now, where Michael and Karen Murray are accused of neglecting their bedridden mother, which prosecutors say ultimately led to the 68-year-old's death.
Right now, we're hearing from the state's final witness, a forensic pathologist who performed the autopsy on Sheila Murray. So let's get back into court.
What the conditions were, what was going on with the caregivers, anything about the situation as it was. I mean, other than what somebody tells you, you don't know anything about it. Is that fair?
Yes. We did not do a scene response on this case because she died in the hospital.
Okay. So I guess the pressure sore, because I can't say cubitus, I'll get that wrong if I keep trying to say it, so I'm gonna call it the pressure sore. The one on her buttock, that was in the earlier stages of breakdown, is that?
Yeah, there was one area that was earlier where it was just more the red pink tissue, and then there was one that was a little bit later where that superficial skin had started coming off already.
You talked about her having erythema, is that how you say that word?
Mm-hmm.
Erythema,
Yes, sir.
okay. That being similar to diaper rash. Is that something that can develop pretty quickly?
Yes,
Okay.
that can.
But you didn't find necrotic tissue or anything that nature in her genital area, anything
No.
like that? Okay. All right. All right. Dr. Cook, I think that's all the questions I have. Thank you.
No questions, Mr. Dawson. No cross-examination. General Wallace, do you have any redirect?
I can just a moment.
You may.
And just we need to mark that autopsy.
I do have redirect, Your Honor. Dr. Cook, I'm going to pass up a document to you. Just to yourself, if you could just take a look at it and tell me if you recognize what that is.
This is our investigator, Laura Scala, her report on the case. So we just call it our investigative summary.
It is Laura Scala, and for the record, that's S-C-A-L-A. Is she somebody who works where you work?
Yes, she just recently.
No, that's.
All right, let's take this opportunity to bring back in National Trial Attorney Michael Jaffer. Michael, quickly, just want to get your thoughts on the cross-examination up to this point.
I think it's been stellar. I think it's been marvelous. The attorney knows exactly what the elements are that he needs to break down. He's trying to break down the knowingness, the lack of intent, the lack of motive. I think he's doing a phenomenal job. I think this actually expert witness is turning into a really good witness for what he's going to eventually argue. I think it's going really good for the defense.
Yeah, he's had that theme throughout, and he's stuck with that theme.
He is stuck with the theme, but you and I have talked about briefly the fact that these attorneys, Michael, I think also are really handling this type of case well in terms of the kid gloves. They're doing it in a way that's not offensive, given the sensitive nature of the injuries to this poor woman.
Throughout, their demeanor has really been perfect.
Yes.
In terms of, you know, the severity and the situation they're dealing with. They haven't gone after anybody, but they've scored their points.
And that's hard to do. That's good trial skills, so it's really nice to see.
All right, looks like the sidebar is over. Let's get back in.
This is our investigative summary. Laura Scala worked at our office for about 10 years. She recently just went back to a different job, but yes, she worked there for many years.
This particular document that I've handed you that was produced by Laura Scala, Am I saying that right?
Yes.
Okay. Is that a document that you also reviewed in the course of your examination of Sheila Murray?
Yes.
You were asked about where you received information that you relied on. Does this document contain information that was provided to the William Jenkins Forensic Center from the family about Sheila Murray?
Yes. So our investigators will reach out to family and they will put details of their conversations or information that they received into their investigative report.
And they were able to provide, the family provided information about her care, her past medical conditions, that type of information?
Yes, ma'am.
And this was something that you used to make your ultimate determination as to cause and manner of death?
Yes.
I have no further questions, Your Honor.
Cross-examination. Mr. Byrd.
Are you using this document? Okay.
I did want to ask you a question I sort of forgot to ask a minute ago whenever you talked about the cause of death. So the sepsis was what in your opinion was the cause of death here? That was
Yes.
it. Now, as far as the contributory factor being these cubitus ulcers, that in and of itself, I mean, you said that didn't help matters, but that isn't what caused Mrs. Murray's death, though, those in and of themselves.
No, I don't think the decubitus were lethal at that time, no.
Okay. That they may have lowered her ability of her immune system to fight off, but those in and of themselves weren't.
Correct.
Okay. All right, I think that's all I have. Thank you.
Mr. Donaldson, any cross-examination?
No, Your Honor.
Any redirect on that issue?
No.
All right. Is Dr. Cook released from her subpoena?
From the state, yes.
All right. All right. Dr. Cook, thank you for your testimony. I will ask you not to discuss your testimony with any other witnesses that have yet to testify, if there are any. I appreciate you coming in today. Thank you.
We need to make sure.
Yeah, let's make sure we've got those copies. They would be, or those exhibits, excuse me, exhibits. Exhibit 18 will be her CV. I think you have that.
Deputy Crane, I can have that one right there.
Yes, ma'am.
19 is the autopsy.
Final witness for the state. We already know, of course, the defendants have expressed they will not be testifying. Do you think proof beyond a reasonable doubt for the murder charge?
Yes, I believe it has. And again, initially I was confused about the murder charge, but it's not about that they intended to murder her. They only had to meet the criteria on the statute for aggravated neglect, which I think they proved.
I do too, especially the sepsis. Coming up, the state officially rests their case in chief, and the defense argues a motion for acquittal. We'll bring that to you here on Court TV, your front row seat to justice.